Is the recording going?
Yes, Mr. Chair.
Thank you very much. Aloha makako, everyone. We will resume the training for commissioners that we started yesterday. By my count, we did about 90 slides of the presentation. We got about 70 to go. And I'm going to push to see if we can get there maybe before we break for lunch. And if that's the case, we'll all have a nice day. So let's try to do that. So let me turn it back to Mr. Orendanker and ask you to continue.
Thank you, Chair. The next topic that we're going to discuss is what we call orders to show cause, and Scott is going to do that for us.
Aloha kako. Okay. Orders to show cause. Depending on where you're coming from, we've heard members of the development community talk about it as a nuclear option that the commission has to kill a project. From agencies and public perspective, it's an opportunity to hold petitioners to representations they've made, agreements they've made for the reclassification of property. And you can find the statutory authority in Chapter 205-4, Part G. And that's where the commission has been given the authority to put conditions on approvals, including the ability to say, if you have not substantially commenced or you are not compliant with representations or conditions that exist, that they can issue an order to show cause. And I'll explain the process for order to show cause, but I think first what I want to indicate is that we have been trying to be proactive as staff, that when we see potential problems occur, our first line is not to try to issue an order to show cause. Our first line is to basically contact petitioners, representatives, and find out what's going on. And usually the reason we do that is one of the main conditions, it's a standard condition in all petitions, it's for an annual progress status report. And especially some of the older approvals that have changed hands a number of times, we're not getting annual reports every year. Sometimes there'll be a lag of 5-10 years, and we don't know what's going on. We don't know if any progress has been made. We don't know sometimes who owns the property anymore. And when that happens, we start, and we've flagged it, we start trying to identify, okay, who owns the property, try to get in contact with their representatives and find out, hey, look, we need an annual report. We need to find out where things are at. Are you having trouble? Let us know. Are you intending to do a different project now? What is that going to entail? So we try to be proactive rather than jumping to an order to show cause. And that's why more recently we've been having more of these status reports. And those status reports are an opportunity for a petitioner to come in and talk to the commission and say, hey, we still intend to do this project. However, we might need to change certain things. So we do anticipate coming before you in the future with a motion to amend for one reason or another. That's a great opportunity. We've recently did that on Maui for affordable housing project that Maui County has going on the island of Lanai. That was useful because not only did it update the commission, it updated some of the state agencies that were involved, including the Office of Planning and Sustainable Development, so that they knew some of the things that they might need to do to help the county move their project forward. So the order to show cause is a very formal process, and it's usually triggered when it can be triggered by a county agency. It could be triggered by a state agency. It could be started up by a member of the public who believes that a petitioner is not complying with conditions of their approval. They can file a petition with us. They're going to have to state the case, state the reasons why. And the LUC then holds a formal hearing. And then the petitioner, well, in this case, the person who files the motion for an order to show cause has to come and provide their evidence. Why do you believe that there's been a breach in this contract? The petitioner obviously has an opportunity to counter any of that information. Yeah, flip to the next slide. So the first box shows motion for order to show cause. It can come from anywhere, and it can come from the commission themselves. We can trigger it because we haven't gotten any contact from a petitioner for a long period of time. We don't know the status of the project. We try to do that with a status report instead, but in the absence of compliance, we can take this path.
Yeah, this is Commissioner Giovanni. In our recent hearings where we've had status reports, one of the options available to the commission was to accept the status report as presented as being adequate, or to order a show cause. So that's a time in which the commission can make this action. I just wanted to clarify that.
Right, and that will be based on evidence that's presented on the record.
Yeah, it's an informed decision.
It's an informed decision. Basically, if you've got a reason to believe that there's been a failure to perform, you can move forward with a formal order to show cause proceeding. So as you see on the box, progress reports, no further action. But if we find there's a reason to believe that there's been non-compliance, we can order an official order to show cause hearing to occur. That's a formal evidentiary hearing to determine if there's a violation.
There are a couple of nuances to this. First of all, Scott is right. We hesitate to use motions for order to show cause. It is the nuclear option, but it's the only thing in our toolbox. And we had 12 years ago, we tried to get the legislature to give us more tools so that we weren't, our only option was to end the project. We tried to get them tools to allow us to work it out. And that stems from the Bridge on Alea case. One of the key issues on whether or not we can even revert a piece of property is whether or not there's been substantial commencement. What substantial commencement is, we're not sure of. The Supreme Court didn't give us a lot of guidance. But one of the things that was very clear about the Bridge on Alea case is that we don't have the ability to say to a developer, we don't really want to end this project. So if you do X by such and such a date, then we won't issue the motion to order to show cause. Because once you do that, whatever you're asking them to do is probably going to qualify as substantial commencement. So it's an all or nothing thing. Either you say, okay, we're going to let you go forward, or we have to revert, one of the two, which is not a good thing. When the Bridge on Alea case came down, a couple of developers said to me, well, we won the Bridge on Alea case. And I said, no, you really didn't, because it puts the commission in a position of having to act without giving you the ability to come up with a resolution. Because once they start doing something, even if it's at our request, and even if we issue an order that says, if you don't do this, we're going to revert. Once they start doing it, we can't revert, period. That was the lesson from the Bridge on Alea case. So it's very difficult for the commission, and it's a hard decision, because if a property is in violation, you can't wait. You can't say, okay, well, we'll give them more time, because once you do, if they do a little bit, then we're out, and it becomes the county's role to enforce. So that's why staff sometimes, is proactive in getting these petitions that are probably in violation in front of the commission. Now,
Hold up, Commissioner Lee.
Thank you. Yeah, I understand why you have to be cautious about asking for an order to show cause. I think, we should still not let people go 5 years without giving a status report. Because, you know, maybe the first year, but I don't know about, 5, we should be on top of that more if we want to, produce housing and such.
and we're trying to stay on top of that. I mean, it's a big job because there are a lot of projects out there that are not moving, and so we have to go back through the files to see when the last time it was that they gave us a status report.
Hang on.
Can you tell me how many there are? Because there can't be that many, because we have a count of 40 to 60,000 homes, and so are there like 20 projects?
I don't have that information in front of me, but I can get it. Yeah, we don't have the exact number in front of us, but if you go on the Land Use Commission website and you look at the pre-approved or the existing approved projects, they're organized by island and year. And if you go down like the list of years, that kind of gives you an idea of how many there are, and there are a lot.
Yeah,
I know, and we don't have everything on the website either.
yeah, that's what I mean, because I looked on and it didn't seem like there was that many, so it should be something not that hard to track.
There are definitely a lot.
Then something's wrong, because we
No,
should be,
there's
we
a
should be
lot.
tracking that,
Well, I mean, yeah, okay. Let's back up for a second, because I understand where you're coming from. One of the difficulties that we're having right now is the same difficulty that almost everybody in government is having, and that is that we have 2 empty positions that we haven't been able to fill. Several years ago, I had a conversation with the legislature about that, and that's where we got the planner 4 position. That's how we got Martina's, the position that Martina's in. But right now we're missing a planner 5. So Martina's doing the planner 5 work while we're waiting, which takes her away from the purpose of getting that position was to chase down these things, which takes her away from being able to, go after all these organizations, because it's not that simple. You have to look in the file and figure out how long it's been since we've had a status report. And then 9 times out of 10, you have to figure out who owns the project, because most of the older projects have changed hands a couple of times. So there's actually a lot of work involved. And that was the reason that we got the planner 4 position. Once we fill the planner 5 position, I think that bottleneck will undo itself, and we'll be working further on that.
Yeah, I know, like the city and the OPSD, they have a list, like a master list of all the projects in the pipeline. So I think that's something we should really, do.
Oh, we have that. That's what Martina and Ariana were talking about. It's on the website. It's broken down by island, but chasing down some of those projects is difficult, especially when you don't know who owns it. So it is time consuming. And like I say, the problem is right now is that we're 1 planner short.
So do you have budget, or why aren't these positions filled?
It's a simple matter of, can we talk? No.
If it's a simple matter, tell
Yeah,
us what it is.
DHERT is the problem. I mean, Department of Human Resources and Development. I mean, the whole system of hiring is broken. It's severely broken.
So can you hire a contractor?
No, not under the union agreements. We cannot.
So you have budget approved by the legislature to fill this position, and you have to go through a hiring process with this other department, and they're not hiring for you?
No, well, what happens is that the way it's supposed to work, there's been recent changes to the law. So we're trying to wait to see how that plays out. That might be advantageous to us. But the way it has worked up until June 30th is that if you have a vacant position, our human resources officer asks the Department of Human Resource Development to post for that position. What DHERD does is they put out an ad that says the state is hiring a planner 5. Doesn't say for what division, for what department, what the job duties are, anything. And then what they do is they won't even begin to review the resumes that come in to see if there's any qualified applicants until they have they set a number. It's totally internal. 20
It's usually
applicants.
25.
Yeah, 20, 25, 30 sometimes. And so we end up with a list months later. They then send us the list of the people that they think are qualified. But it's maybe 6 months since they posted. And so we call these people up and ask for an interview, and they say, we already got another job, you know.
And by the time our office receives the list, there's usually only 2 or 3 names on the list.
Yeah.
It's terrible.
It's a totally broken system, totally broken.
Commissioner Lee.
Have you looked into the exception from the Kono decision where if the government can't do it in time and it's a urgent matter that you can contract out?
Yes, I understand that that's out there, but I mean, that's a tough row to hoe. You know, I mean, it would probably take us 4 or 5 months just to get permission to do that, you know, and then we would have to get somebody up to speed. It's a very, this is the biggest frustration. One of my biggest frustrations is the hiring process. And half the time we get applicants under the process who say, well, I didn't know what I didn't know what you guys do. I don't know what I was applying for. I wanted to be a planner for DOT. I didn't want anything to do with this, you know. So the way I understand the changes to the law, the different agencies are now capable of advertising and getting their own applicants and doing an internal analysis of their qualifications so that we can hire. But there are some bigger problems too. I mean, we don't pay well. Our benefits aren't better than the private sector anymore. Planners in particular, are very highly sought after. There's no such, in the state, there's no such thing as training in place other than what I've been doing with Martina. You just can't do it.
You know, governor has a housing emergency proclamation where one of the provisions is speedy hiring,
Yeah.
going past DHERD, HHFDC, other people have used this. So maybe you can talk to Scott Glenn and see if he can help you out.
Yeah, well, I could actually talk to Mary Alice because she's head of the governor's emergency task force on housing, or she's one of the heads. Yeah. I mean, we have to. Well, there was a couple of things that happened. First of all, we couldn't hire anybody until we had paid out. Riley was in that position before. We had paid out Riley's vacation, and he had a ton of vacation. So it was just about a month ago that we got to that point. Anyway, but I mean, these are administrative issues. These are administrative issues that we're working through. But when we're fully, my point is that when we're fully staffed, there'll be more effort and energy focused on this stuff.
Yeah, so I want to go back to Commissioner Lee's original request, which was not about hiring. It was about producing a goal to produce a list or spreadsheet of projects that are delinquent in supply and providing their annual reports. And I'd still like to see that established as a goal.
We can get that to you, but we also have to add to it when we receive new things. So it's a evolving list.
Understand. Yeah. Commissioner Carr-Smith?
Isn't that what Arnold's working on?
No, Arnold's role is to, for lack of a better word, we've started to call him a development concierge. So he's looking at projects that are not necessarily delinquent or in violation, but are not moving. And so what he's trying to do is trying to find out why they're not moving and negotiate with other agencies and county agencies and, other landowners to facilitate those projects moving forward.
So through that process, he must be learning which ones are delinquent, which ones are dead, which
Well,
ones changed hands, all that
yeah,
stuff,
yeah.
right?
I mean, so he's adding to the database, but he's focusing on projects that have the potential to move, not on ones that we don't know what's happening and things. So he's looking at his first criteria when he's looking at things is how many homes were promised, and then he works downward from there. Some of the status conferences that we've had have been a result of Arnold's work. But I've asked him to focus on projects that he can help move along, and he's had some success with that. We had a developer tell us the other day that there was a bottleneck at the county that once Arnold got involved just disappeared, and now the project is moving forward at a much more rapid pace. So that's the type of thing I want him to focus on. I mean, I understand that this staffing problem is very frustrating for all of us. I don't have a secretary. That I think we can resolve a little more quickly, probably in the next month or two. But I mean, when you put out an ad for Planner Fives for the entire state and you only get a list with one person on it, I mean, it's tough. It's really tough. So.
This Commissioner Giovanni, so you mentioned in your discussion, the words substantial commencement.
Mhm.
Is there more in this training on that topic coming up, or should I ask my question?
You can ask your question.
Okay, so can you elaborate on what substantial commencement means the best you can from Bridge on Alea decision, and how that, more importantly, how that impacts the business of this commission?
Um, substantial commencement is a very difficult issue because the Bridge on Alea case was almost like the US Supreme Court case on pornography. I know it when I see it, And I actually disagreed with the courts on the Bridge on Alea case on whether or not there'd been substantial commencement because it was a $750 million project. And they went and saying, look, we spent $40 million. I mean, if you look at it at a percentage, it wasn't substantial.
But you don't get to decide.
No, I don't get to decide that, but I'm just giving you an idea of how difficult it is to define substantial commencement. If my belief based on Bridge on Alea is that if a developer has made substantial progress and spent substantial amounts of money with regard to infrastructure or in any way moving dirt, then that's probably substantial commencement. The only time that I would say there has not been substantial commencement is if the developer can only show soft costs.
So I want to take it a little bit different for my fellow commissioners. So the only enforcement tool that we have for a delinquent project is to revert it. So if we had approved a project and reclassified the land from, for example, from agriculture to urban, and we have all these conditions, the only thing we can do if it's a delinquent project in terms of our enforcement ability, not the county's, but ours, is to revert it back to its original classification.
That's correct.
However, if it's been determined one way or another that substantial commencement has occurred, in other words, the developer has proceeded to do something which can be interpreted as substantial commencement, then even that enforcement action is taken away from us.
That's correct.
That's the nuts and bolts of it, correct?
So actually, from the Bridge on Alea case, if there has been substantial commencement, if the commission still believes that the project is not moving forward, it's not compliant. If they want to revert the property, they cannot use the order to show cause process. They would have to go through a regular petition process.
I didn't talk about that because it's a non-starter.
It's a non-starter.
Yeah, because
So-
right.
we would have to put on the case.
Yeah.
I mean, staff, and we're not set up to do that.
No.
Theoretically, the Office of Planning and Sustainable Development could put on the case, but.
So for all practical purposes, if substantial commencement has occurred on a given project, no matter how delinquent it is, in our mind's eye, we don't have the ability as a commission to revert as a practical matter.
Once there's been substantial.
To revert, yes. Do we have other avenues to enforce? I think we do.
What are they? I never heard
Well,
of them.
One I think is a progress report. You know,
But that's not enforcement, Scott.
it's not enforcement per se, but oftentimes it identifies issues or weaknesses
Yeah, I agree.
that are out there
We,
that then lead to
Solutions.
compliance.
yeah, so we can help them along, but from a hardcore enforcement perspective, we don't have any.
We don't have a.
Commissioner Lee.
Scott, what about if there were conditions given when the DBA was granted and they don't meet those conditions, such as you need to do this by this date or provide this, and then that wasn't done? Wouldn't that be something that you could come back for?
Yes,
So we should be very careful with our conditions to make sure that
absolutely.
Yes.
they're gonna
The more
move
the more
forward.
clarity you have in your conditions, and you're gonna see this as in your tenure as commissioners, particularly when we're handling motions to amend, you're gonna be looking at old conditions that you're gonna wonder, wow, this creates so much gray area.
Yeah.
Now we have to try to clean this up.
Yeah.
Why weren't they more careful before?
Yeah, it's
Yeah.
not uncommon for us at this point to say, who the hell drafted that? You know?
Or if they come back to amend, then that's where we could also,
Well, yeah, I mean, there are several different ways you can get to a motion for order to show cause. One of them is if they come back to amend a condition and we don't agree with the amendment. But that's rare. I mean, usually when a petitioner comes back to amend a condition to reflect what the current project needs are, we usually grant it. I mean, you know, we're not trying to stop the projects. This is not about stopping projects. In my time, we've only had a couple of motions for order to show cause that ended up in reversion. One was, or several of them were actually at the request of the petitioner. We want to revert our property back, and they can't just agree to that. We have to go through a motion to order to show cause. And the only other one that we've had that I think that we did was the Waikoloa Mauka case, and that was an interesting case that somebody could write a book about, but it was basically a scam. The owners were you know.
So I want to respond to Commissioner Lee. On a couple of hearings or petitions before us, we actually attempted or in deliberations to articulate a condition that defined what substantial commencement would be for that specific project. And I don't know that we were ever successful in articulating such a condition.
Yeah, no, it's very difficult to do that.
okay, so we do have some tools, but it all kind of starts with tracking them, the projects and status reports. Otherwise,
Yeah.
we're not even going to get to the next step.
Yeah, and like I said, the original reason for me asking the legislature for the Planner 4 position was to stay ahead of it. And once we resolve our Planner 5 issues, that bottleneck should end. And believe me, we're working diligently on it. We're also working diligently on hiring a secretary before Ariana crashes and burns. But because she's basically doing 2 jobs right now, but you know,
Thank you,
the
Ariana.
hiring process is difficult. There's one other thing that, go ahead. Are there any other questions before I have another thing to bring up? Go ahead.
So the commission previous to this one determined that Inalea had not had substantial complete,
Well, okay, so the facts of
a
the
few
bridge on
commissions
LA,
ago,
because
yeah,
it was,
before
yeah, it was
me.
about 4 or 5 commissions ago, actually.
Okay.
Commissions ago. It was well before my time, but because I had to deal with it because the court case was going on when I got here. What actually happened was that, I mean, there was so many things happening in the background of this. Bridge Inalea, the company that bought the project, was not a developer. Okay, what they were basically an investment company, and they would buy investments, and then in the case of real estate, they would sell off the development rights to portions of the project with a buyback clause and monthly payments, right? And then they would take that money and they would invest it in, they claimed that in a bank in somewhere in Southeast Asia where they were getting 30% return. I mean, that's what they claimed, and that's what they tried to prove in court. They sold off a portion of the project to DW Inalea, and DW Inalea bought the portion of the project that was supposed to be affordable housing. It wasn't happening. It wasn't getting off the ground, in part because DW Inalea couldn't get funding, and they were already paying for lack of a better word, the mortgage on the property. And so the commission at that time, now remember, this is just what was in the court pleadings because I wasn't there, none of us were there. The commissioner at that time decided that what they wanted to try and do was try to work it out. So they kept saying that at 3 different points in time, they said to DW Inalea, if you get X done by a certain date, we won't revert the property. And it was sort of, they were trying to work out a settlement, basically was about what was happening. And so DW, the last thing that they did was they said, okay, if you build X number of units, I can't remember how many,
16,
60 units,
16.
16 units by a certain date, then we won't revert the property. So what DW did is that it put up buildings with no sewer connection, no water connection, I mean, they were not inhabitable. And then, and they said, okay, look, we did it. And the commission said, no, that's not what we meant. We meant habitable 16 units. And so they reverted.
I understand that, but at the same time, they built 16 units.
Well, that was the position.
Were complete except for connections to
Yeah,
utilities.
but what happened was that the commission said that wasn't what and they reverted. And so then DW Inalea, no, it was Bridge Inalea actually sued over that. And it went all the way up to the Supreme Court. And that was when they came up with.
Sued, you mean appealed?
Yes.
The decision.
Yeah. That was when this substantial commencement definition sort of came down. Subsequently, Bridge Inalea tried to prove in federal court that there had been a taking.
Wait, you skipped the important part.
What?
The Supreme Court agreed with the and did not agree with the action taken by the commission.
That's correct.
Right.
Overturned
So
the
what
action.
constituted unconnected 16 units, uninhabitable, in the Supreme Court's eyes, it did constitute substantial.
That's correct.
Commencement.
That's correct. So they agreed with you, Nancy, actually, is what I'm trying to say. And then, but it turned out that there were no damages involved and the state didn't have to pay anything. But the reversion was undone. There's a lot more history to it too. What's his name? The attorney on the Big Island who sued over the EIS.
Vatusik.
Yeah, Vatusik. He sued on the Big Island. Yeah, district court, and was able to succeed in a case saying that the EIS was inadequate and had to be redone. And that stalled the project for God knows how many years after that. I believe when the current administration came in, they gave the project the go ahead, but nothing has happened. because DWI&LA is basically bankrupt.
I have one final question on this. Do commission members ever go out to the sites
Yes,
to see? So did commissioners go
Not
and see
individually.
that site?
not individually yet, but as a group, we haven't had a site visit in a long time because we haven't had a DBA. Before we do every DBA, we always do a site visit. So, but we've also done a couple of site visits when motions implicated, or the need for the commissioners to see what was happening. So,
Yeah, let me say that if any commissioners feel the need for us as a group to do a site visit, I'd like to hear it, and we try to get organized.
yeah, we welcome that. I mean, I think it's good for commissioners to see the site. We can't do it on every project because it becomes a budgetary issue, right? We gotta, because it's, unless we're having a hearing on that island the same day, it's an added flight and expense and, all the rest of that.
Pretty
But-
sure that some might say that there's a sunshine issue there as well.
No, we don't, we notice it. It's a sunshine visit. The public is welcome to join us. They're not allowed, we tell them they're not allowed to ask questions because there's no court reporter with us or anything else, so it won't be part of the record. But the commissioners are allowed to ask questions of the developers. And they're allowed to follow along. Okay. One other item about the orders to show cause is that at the LUC files an order to show cause, but what that is is a order to the petitioner or the developer to tell us why we shouldn't revert. So in other words, the burden is on them. Because if we have reason to believe that there's been a violation, enough evidence to believe there's been a violation, and issue the order to show cause, they have to prove to us why we can't do it. So the burden is on the developer. not-
So isn't it a commission decision by vote to issue that order? Staff
Yes.
can't issue it.
Yes, that is correct. That is correct. We can't do it unilaterally. It's always a commission decision.
So there's a preliminary hearing based on someone filing a motion for an order to show cause.
I just wanted to clarify
And
it's a
evidence that
commission
comes onto the
action.
record, then the commission decides whether or not they've got a reason to believe that there's been noncompliance. If so, then the commission issues an order to show cause requiring the petitioner to come in.
Let me give you an example of a real life example of something that almost happened and it resulted in an order to show cause, but was resolved. We got information on a particular project that one of the conditions in the DNO, and I'm kind of paraphrasing here, was that they developed a drainage system that was supposed to go in conjunction with the military because it was adjacent to military property. We got word on them, I can't remember how, whether it was through the military or through somebody else, maybe some of the neighborhood board, that they were no longer going to do that drainage program.
That was actually disclosed in an annual report.
Yeah, it was disclosed in an annual report. So, I mean, when we know that there's going to be a violation like that, once we know that they're not going to do it, adhere to the condition, then we can issue the order to show cause. And then they have to prove to us that even though they are going to violate that condition, we shouldn't revert the property because they have a good reason as to why they're doing what they're doing that we should accept. So that's kind of the way the process works.
And it leads down to, you have the evidentiary hearing. You may find that, yes, they are non-compliant, they're in violation. So you have options. You can revert the property based upon that. But there's also opportunities for, and usually this is what happens. The petitioner doesn't want a reversion of their property, and they recognize that they've been in violation of conditions. And based on the evidence on the record, they agree, you know what, we're gonna come in with a motion to amend. We understand that we're not in compliance with conditions. We're gonna come in with a motion to amend it, tell you how we're going to actually fix it.
And the commission has the ability to say at the motion for order to show cause hearing is that, okay, we won't revert the property if you come in with a motion to amend in so many months or so many days.
And in my mind, the more likely scenario is they come in and say, we're non-compliant, but we've substantially commenced. So you can't revert anyway.
Actually, what we found is that the specter of an order to show cause, even to have the order to show cause hearing, we've been told is a financial detriment for them to seek investment dollars. They want to avoid that.
Sure.
They're more willing to
Do a motion to amend.
come in with a motion to amend to address those issues rather than trying to, pin their hopes on, oh, we've substantially commenced, therefore
Fair
we
enough.
can violate
Fair
anything
enough.
and everything.
Yeah.
And I gotta tell you that outside of the motions for order to show cause, which were requested by the petitioners themselves, the only one that we've really ended up in reversion was the Waikoloa Mauka one. And I could spend 10 minutes explaining why that was such a scam, but basically it was a Ponzi scheme by a bunch of Ukrainian businessmen. Yeah,
Let's move on.
yeah. So,
Yeah. So just really quickly though, the question that Commissioner Carr Smith had about the Regina Lea, yes, they did put up 16 shell buildings, but what the commission had conditioned them to do was not just 16 outer shell structures. They required that there were occupancy permits issued, meaning that they had to be fully connected to utilities, habitable dwellings, not shells of dwellings, but habitable dwellings. And that was an important distinction. The commission was concerned that yes, you could just build the structures, but not be connected to any infrastructure. And that is exactly what occurred. And that's one of the reasons why the commission then decided to move forward with an order to show cause.
one of the things to note about what occurred there was that you can't draft a DNO around the substantial commencement clause, because that's what they tried to do. They tried to draft a DNO that said, if you complete these 16 units, and they meant habitable units, by such and such a date, then we won't revert. If you don't finish them by then we're gonna revert. And so they were trying to get around the substantial commencement clause, and they can't do it. That's what the courts basically said, is that you can't get around the substantial commencement clause.
Yes, and that's, and in ways, that's a cautionary tale for you commissioners sitting now and those in the future, is that do you try to allow them more time to substantially commence? Or do you say, look, based on all the information that we've got at this point in time, you're not gonna comply, and therefore we should just go ahead and revert now? Because if you allow them to do the substantially commence, then there's a problem with how you might be able to enforce things in the future.
Okay, I think we're done with that. So next is boundary interpretations. Is that right?
Yay.
Yeah,
This one should be fast.
Martina.
Boundary interpretations are typically done in-house by staff. Oh, next slide, Ari.
This is something that I should start out by saying this is something that the commission never deals with, but we thought you
Sometimes they
should know
do.
what was happening.
Yeah.
Okay, so go ahead.
So, yeah, so they're mostly done by staff, and it's basically a geospatial analysis of where the district boundary line lays. So, we overlay the district boundary line and property lines to determine where the lines are, and that's important for permitting processes. And that's done typically with the staff, but if someone disagrees, they can bring it to the commission in the form of a DR. And there are rules on how to conduct boundary interpretations for the property owner to follow and the staff to kind of follow and figure out along the way. But that's boundary interpretations in a nutshell. It's very internal.
There we go. The way these come up is that somebody wants to build something on their property. And the planning department or the Board of Land and Natural Resources, if it's conservation land, says, well, you got to get a boundary interpretation first because we don't know what the boundaries of your property are from a district standpoint. Because there's always some controversy usually over whether or not a portion of the property is in ag or in conservation or whatever. The Land Use Commission is tasked with keeping the boundaries. We are the organization that holds the maps for all of the boundaries of all of the districts in the state. And so when somebody are told they need to get a boundary interpretation, then we have a process and they give us meets and bounds and things like that, and we do the boundary interpretations. But they usually don't come in front of the commission.
Commissioner Imani.
I was gonna ask about that. So are those surveyed and do you evaluate surveyed meets and bounds and you guys kind of negotiate that, or how does that?
Well, it's
work?
not a negotiation process. What really happens is, yeah, it's a
Yeah.
Martina can speak to
So we get the meets and bounds certified surveys from the property owner. And we overlay the district boundary line, so our personal maps on top of those. And then we'll then send it back to the landowner to get the survey again with the line on top of it to get those meets and bounds measurement to determine where the line is in relationship to
district
the
boundary line.
property. Yeah. Yes. Yes.
We're gonna move on to sunshine.
May
law.
we bathroom break?
Yes, anytime Ariana wants a break, we'll take a 5-minute recess. It's 9:55 and we will resume on the record, sunshine law. Mr. Morris, are you online with us? Mr. Morris,
Yes, I am.
so you asked for an opportunity to comment when we got to this point, and I'm
Yes.
giving you that opportunity.
Thanks so much. Can I ask that we move back to slide 8, please?
Slide 8.
Page 8, yeah.
So Ariana. All right.
Okay, so,
Is
this the correct one?
yes. When we got to this slide, a question came up about matters that come up before the commission that are either agendized or perhaps before they get agendized. And one of the way I understood Commissioner Carr Smith's question was that if commissioners aren't supposed to discuss matters between them amongst a group of people under the Sunshine Law, then is that okay before it gets placed on an agenda? And that's how I understood the question. And I think there was a suggestion that perhaps the Board of Land and Natural Resources had been advised that if it's not yet on an agenda, that it's okay to have those sort of discussions. And I pushed back on that because that wasn't my understanding. And under Chapter 92, which governs the Sunshine Law, there's a definition under Chapter 92-2 of what board business is. And board business includes matters that are both pending before boards and commissions, but also matters that are reasonably anticipated to arise in the foreseeable future. So in my mind, that was the distinction I was trying to articulate, that it doesn't necessarily have to be a matter that's currently pending. Board business can also include matters that are anticipated to arise in the foreseeable future. So I think that was an important discussion in the context of sunshine law that's shown on this slide. But then I got a call this morning, and the question was posed to me, have you sort of got something for us? And I was told that perhaps the question related more to a different matter on this page about ex parte communications. And so the question in this context was, well, can a board member or a commission member talk with someone about a matter that might come up before the board or the commission individually, not in a group, not a sunshine law issue, but just from an ex parte communication standpoint? So that's not how I understood the question, and I have to apologize if I misunderstood it. And I was sort of giving the sense that, I might need to do a little research on this, and I got a little pushback on that because it's such a timely question. So I wanted to give a little feedback on the response in the context of ex parte communications and what may have been told to the Board of Land and Natural Resources. The first thing I want to point out is that the Board of Land and Natural Resources and the Land Use Commission have separate rules, administrative rules. Administrative rules have the force of law. The Board of Land and Natural Resources has an administrative rule, which is 13-1-37, that talks about ex parte communications. And what that rule for the Board of Land and Natural Resources says is that if there is a contested case matter that is pending, that ex parte communications between a decision maker, like someone on the board, and someone who's a party or a witness in that contested case, those kind of ex parte communications are inappropriate. And so that talks about contested case proceedings. The Land Use Commission has their own rules. Their rule 15-15-62 also talks about ex parte communications. But that rule talks about proceedings before the Land Use Commission. It's not limited to contested case proceedings. So it's a good example of how administrative rules can differ between various state agencies and boards and commissions. So I think because the rule 15-15-62 for the Land Use Commission talks about proceedings, it could be interpreted in a broader way that ex parte communications about board business are inappropriate. And I think that's generally been the practice of the commission. That rule also gives a list of ex parte communications that are okay. Some of those communications can be authorized by the Land Use Commission. It also says it's okay to have ex parte communications about the status of a particular matter. It also talks about communications where there's been an agreement amongst the parties to a particular proceeding that ex parte communications are okay. And there's a reference to communications with respect to media communications. So you'll see that there are certain kinds that are okay and some kinds that aren't. And I think the best practice is to try and avoid it. And as staff and Dan Orendanker have said, going through staff, if you hear those kinds of communications or questions, is probably the fairest and most appropriate and conservative way to deal with this. It did sort of raise in my mind a good suggestion I have, which is that I have a little binder that has Chapter 205 as well as the set of administrative rules. And obviously, as the attorney advising the commission, that's an obvious part of what I should have in my resources. But I think for each of the commissioners, in terms of an orientation, I think it's useful to have that binder and to look through it. They're not that long. The rules nor the Chapter 205 are that long. So it's a useful tool to have handy. And in particular, in talking about ex parte proceedings, that 15-15-62 rule is particularly useful. I also want to point out that there's another rule that is 15-15-34 that says that the intent of Chapter 205 is to establish quasi-judicial procedures. And quasi-judicial procedures are where this ex parte communication problem arises, because when you're acting as a judge or in a quasi judicial capacity like courts, they can't be having a conversation with one of the litigants in front of them when they're acting in that judicial capacity. And in the same way, when the Land Use Commission is exercising their role, which broadly speaking is a quasi judicial role, the same type of constraints might apply. So that's sort of a general comment. And it led me to also, because it was a little stressful for me trying to answer, as we do a training about everything the Land Use Commission does, and people think of hypothetical questions on these areas of law that are difficult and often gray areas, it's really hard to answer on the spot. And sometimes I might need a chance to do some research and give a more careful response. But I do think that it's good to know there are levels of attorney advice from your deputy AG. One level of advice can be done in a formal published opinion that's approved by the Attorney General. We can also give legal opinions in a letter form that are either approved by the AG or informal AG letter advice. And we can also give one-to-one advice in a more informal context. There are also opportunities during Land Use Commission hearings for executive sessions, which require a particular number of members to vote for that executive session. I believe it's 2/3 of the members present. And so those executive sessions have their own sort of array of rules. And I provided to Dan Orendanker a nice little summary that the Office of Information Practice has provided that talks about what topics can be covered in executive sessions and how minutes need to be taken and how you limit the scope of those executive sessions to the topics that you went into an executive session for. But there's also advice where we're in the middle of a Land Use Commission proceeding meeting and people will turn to the deputy AG and say, oh, what do you think? And that's an appropriate question. It's not always one that I or other deputies will be prepared to answer on the spot. But if we are, we sort of do a mental calculation of, do we give complicated legal advice that might be controversial and perhaps confidential on the spot? Or can we give some general guidance that we know off the top of our head? So it's that sort of difficult discretionary call that we're trying to make sure we provide good public service for you folks, but also that we don't sort of blurt something out without doing the work we need to do to make sure we've carefully evaluated a particular issue. So those are some of the tensions that arise and just a little snippet on what my role is in this whole process. So thank you for the opportunity to give a couple minutes on that topic.
Thank you, Mr. Moritz. I'm going to turn back to Commissioner Carr-Smith to see if that helped or you have further questions.
Yeah, thank you, Dan, for that.
So, Dan, I think the original question was we were talking about ex parte communications that might lead to a disclosure before a commission during a hearing. So I think the general rule is that, if I interpret what you're saying correctly, is that if a matter is anticipated to come before the commission, or if it's in the pre-application stage with staff and it's not yet a complete application and it's not yet been agendized, we need to be very careful if there's a reach out by the developer or the petitioner, prospective petitioner, and they want to carry on some Q&A with an individual commissioner. You just need to be careful. But if those type of discussions do occur, I think there's an obligation on that commissioner to disclose it to the commission at the evidentiary hearing, and they will deal with it at that time. Is that fair?
Yes, that's definitely a fair comment. And I had one more thing in my little notes I want to slip in, which is that, in sunshine law, which is the next topic that's going to be discussed, it's really critical that groups of people not discuss matters that either are pending or might come before the commission. And one thing that sort of caused me pause yesterday we were talking about general concepts of the role of the Land Use Commission in particular cases even. And one of the topics that came up was either the landfill case or the county's IAL petition. And I think that's a good learning or teaching point to know that we really shouldn't talk about specifics of cases in this training session on matters that might come before the board. For example, that county IAL petition is pending before the High Court and may well come back before us. And so it's not on the agenda. So I think our discussion about the LUC's role and their decision-making process needs to be a little more generalized, which I think there's been an effort to do, but a couple times it seems like some specifics crept in, and that probably is not an appropriate thing under our sunshine law, because it would be a group of us discussing something that wasn't on an agenda.
So you raise an interesting new question in my mind, Mr. Morris. This is Commissioner Giovanni. In my mind, there's a difference between clarifying what factually occurred during a prior matter that did go to a DNO. It might be related to a perspective going forward, but if the discussion is confined to what occurred in a completed action, what's wrong with that type of a discussion?
No, I agree. I understand it's sort of just the historical facts and not sort of what we thought or something. But if, for example, a matter is likely to come back before the board and there's sort of a discussion of sort of, staff's thoughts and, the rationales, it may be more than just sort of the status of the case or sort of, the bare bones facts. It's not a bright line. And I would have jumped in if I thought something was really out of line. It just made me think that it's something to keep in mind about matters before the board or before the commission or that might come before it. But I agree, just, the fact that there was a case and that case is on appeal, perhaps even the bare bones of the case, but you have to think in your mind of, we certainly don't want any discussion of positions or rationales or sort of group discussions about the case. That would be the concern.
Understood. But in my mind, lessons learned from closed cases are great examples that help facilitate the training.
And I would
Surely.
agree definitely on a closed case. Your point about a closed case is a very good one, that if the matter is concluded and everyone knows it's concluded and not likely to come back, that is fair game, really, for what the board thought. Let's talk about it. Let's use it as a learning opportunity.
Commissioner Lee.
Mr. Morris, this is Commissioner Lee. Isn't that line a little less bright when it's just two people talking to each other and not asking for a commitment to vote?
Well, that is a very good point, that two commissioners can meet and have a discussion about matters before the commission without violating sunshine law. And it's sort of that line of, if it's more than two, if it's three, then you get into a problem. It's sort of this oddly arbitrary line. So that is a correct observation.
And then there's also the issue of serial communication. So you can't just go one by one and pass that along, and that's also not allowed. Isn't that correct?
Absolutely.
Okay, thank you. Back to slide number.
I did want to clarify one thing, that one of the questions that you were asking our deputy AG, and you are focusing on ex parte with respect to petitioner and or their representatives, but it's actually ex parte with any parties. So that could include Office of Planning, Sustainable Development.
Sure.
It could include the county representatives as well, and including any witnesses that might be involved.
Thank you,
Very good.
Scott.
Okay, slides 96. It's 97.
We'll go through this section fairly quickly.
Yeah, you always promise that, but never
Yeah.
happen.
I lie. I can't help it. But, okay, all our meetings are subject to the sunshine law. I mean, this is something that we already talked about, basically. The sunshine law in brief Next slide. Yeah. And it's fairly easy. All meetings of the state and county boards are required to be open to the public. Agendas, meetings have to be noticed, and agenda must be posted no less than 6 calendar days prior to the meeting. We have to keep minutes as well as a video recording. We run our agendas by the Attorney General to make sure that they conform with Chapter 91 and 92, or 91. And so that they're worded in such a way that we can do the business that we need to do. The unfortunate thing about, unfortunate thing about the Sunshine Law is that we have to, our discussions at the hearings have to stay within the four corners of what was noticed. We can't bring up another matter or whatever. What you can do if you want to talk about something that's not agendized is ask the staff to agendize it for a future meeting. Public is allowed to provide written or oral testimony on any agenda item. You can limit the amount of time. We're not required to accept oral or written testimony unrelated to items on the agenda for the meeting. And we just finished talking about this. More than 2 commissioners are prohibited from meeting without notice if discussing business matters. Staff are not decision makers. We're not subject to those restrictions.
So if Commissioner Lee and I want to talk one-on-one with each other,
Mhm.
I understand we can do that. Can we include a member of staff to be
Yes.
part of that discussion?
Yes,
So
you
we
can.
can have 3, like if we want you and Scott to join us.
Yeah.
Or Scott and Martina, that's okay.
Yeah.
Okay.
That is fine.
Commissioner Lee.
Maybe this question is for Mr. Morris, but isn't there also another exception where multiple commissioners can meet with the department head or the governor on a matter that's not before the future or anticipated to be agendized?
I'm going to give that one, I'm not sure. And I don't know off the top of my head. One thing I will mention is that the Office of Information Practice administers Chapter 92, which is our Sunshine Law, and they take a very proactive role in terms of providing advice to us as deputy AGs or members of the public that have questions on Sunshine Law, and they're very, very responsive and good. If I don't find an answer in my review or research, I call them up more and more frequently, and that's been a useful tool, but I don't know the answer to your question.
Yeah, I asked that because I think I knew the answer, but it would be good to have your endorsement of that as well. And maybe a bunch of us can go to the governor and ask for staffing for the LUC as an example.
Yeah.
Thank you.
Okay, so Mr. Morris, you'll follow up if you get some better information for us on that question.
Yeah,
Yes, I will.
would be interested in that question. I could tell you a funny story about way back.
No
when,
time for
but
that.
we
We'll
don't have
move
time.
forward. Okay,
Yeah.
public trust doc.
Okay,
Brief or whatever.
and I'm sorry about this because this is going to take some time,
This
and
is
there's
a
going to
lot,
be,
yeah.
and there's going to be some redundancy, because what we've done is we've given you the public trust doctrine briefing that we gave commissioners up until a month ago. And then we had a case come down about a month ago that reiterates everything and kind of expands on it in certain places. And I want to talk about that case in detail, and some of it is going to be redundant, but I think it's worthwhile going through. The public trust doctrine is probably the most important doctrine that we have to deal with in our hearings. And the courts have actually expanded that recently to include almost everything that we do, not just our contested cases, right down to rulemaking. And so it's got to be on the forefront of your mind at all times. The Waiahole water decision in 2000 was the first real expression by the Supreme Court of what the public trust doctrine is all about. The public trust is the right of the people to have water, because that was a water case, protected for their use. And they talked about comprehensive planning being intrinsic to the public trust concept, which also demands provision for traditional and customary Hawaiian rights, wildlife, maintenance of the ecological balance, and scenic beauty. Remember that, because when we talk about the case that just came down, that gets further expanded upon. And this arose from the Hawaii State Constitution, Article 9. One more. Article 9, Section 1. For the benefit of present and future generations, the state and its political subdivisions shall conserve and protect Hawaii's natural beauty and all natural resources, and so on. All public natural resources are held in trust for the state by the state for the benefit of the people. There is an affirmative requirement to ensure that public trust resources are preserved for future generations, and that decisions do not overly impact the public's right to utilize those resources. The first consideration must be the long-term health and sustainability of the resource. When there is doubt about the impact of the resource, the agency should err on the side of caution. And what that has evolved into is the concept that commissions, in particular, act as trustees. I mean, you're not making a decision based on, what you think is best, but in terms of balancing project value against public trust or the public trust considerations, you are tasked to act as a trustee to preserve those resources for future generations, which means that if the proposed action is going to destroy that public resource so that future generations cannot enjoy it, then you can't grant the petition. This applies to watershed protection, historic sites and cultural sites, environmental natural resources, air, water, minerals, and energy, cultural resources, and the ability to access land for cultural activities. For LUC purposes, the public trust doctrine is compounded by federal environmental regulations. So, Endangered Species Act and things like that also come into play. Public resources are inextricably interlinked with the right to traditional and customary practices. Without the resources upon which to practice, there can be no practice. And once again, I caution you to keep that in mind when we discuss the case that just came down. The state must act, being commissioners, as a trustee and not simply as a good business manager. It must not relegate itself to the role of a mere umpire passively calling balls and strikes for adversaries appearing before it, but instead must take the initiative in considering protecting and advancing public rights and the resources at every stage of the planning and decision-making process. That's from the Waihoʻoli case. Now, a case that evolved from a land use commission decision was the Oka'aina versus the Land Use Commission. And that has basically set up a program on how commissions are supposed to handle public trust doctrine issues. The state and its agencies are obligated to protect the reasonable exercise of customary and traditional exercise rights of Native Hawaiians. Agencies are obligated to make an assessment independent of the developer or the applicant of the impacts on traditional and customary practices of Native Hawaiians. Now, what that means, make an independent decision, is that we can have petitioners or parties come in and say, look, we satisfied Kapakai because we identified the resource. This is how it's going to be impacted, and this is what we're going to do to protect it. But that doesn't mean anything. The commission has to make its own independent decision on whether or not what's being proposed is adequate, and or whether or not there are other conditions that need to be put in place to protect that resource if possible. And that cannot be abdicated under any circumstances to another party, a third party. It's the obligation of this commission.
This is Commissioner Giovanni. So I'm glad you stated that the way you stated it today, which was different than how I heard you say it yesterday. And it's an important distinction in my mind, so I want to make it clear to all fellow commissioners. the commission has a duty and a responsibility and the authority to determine if the Kapakakai analysis that is put forth by a petitioner is adequate and substantially satisfies the requirements. But the commission in of itself doesn't do the analysis that is the man hours that are put into place to determine and answer the questions. Is that
Well,
correct?
that's somewhat correct. The commission has to decide whether the evidence presented before it is credible and is enough to satisfy the Kapakakai criteria.
Yes,
But it does not go out and
do the field.
independently, do or ask for cultural resource studies and the rest.
Correct.
Yeah.
And in my recent experience, there are a growing number of consultants, qualified consultants within the state that does that work. And it costs thousands of dollars and takes a lot of time.
Yeah,
Okay. And our commission and our staff does not do that field work.
right. That is correct.
Thank you.
There are three factors known as the Kapakakai analysis. You have to identify the valued cultural, historical, or natural resources and the extent to which traditional practices and resources are exercised. As Jonathan Scheuer likes to call it, what you got. The extent to which those resources will be affected or impaired by the proposed action. What you doing? The feasible action to be taken to protect rights and whether the action will irrevocably harm the resources such that it cannot be enjoyed by future generations. What you're gonna do. So those are the three criteria that you'll see over and over and over again in EISs, petitions, whatever, that have to be addressed before this commission can render a decision. All resources in the public trust must be identified on the record. Impact on the resources must be clearly and fully analyzed through the evidence. Any mitigation measures must be identified. The long-term loss, if any, needs to be presented to the commission. Only after all the evidence is presented can the commission render a decision. If there are still questions about the impact on the natural resources or whether or not the resources exist, the commission must err on the side of caution. And what that basically means is that if the commission doesn't find what's put in front of it credible, they don't think that the analysis was done by the petitioner in a proper manner, not all the resources were identified, anything that's associated with that analysis, they can't render a decision. That doesn't mean they have to deny the petition. You can always say, look, we don't think you did it. We think your cultural resource analysis is inadequate because public testimony was that, this area was used for additional things other than what you identified. You can send them back to say, hey, look, you got to come back before us after you've done this analysis. So it's not a death knell, but you cannot move forward with approval until you've got all the information that you need. The promise of preserving and protecting customary and traditional rights would be illusory absent findings on the extent of their exercise, their impairment, and the feasibility of the protection. All parts of the Kapakakai analysis must be fully represented by the facts and contained in the decision order through specific findings and conclusions to avoid appeal. And once again, it's good if the commissioners comment when they're in the discussion period on whether or not they feel Kapakakai has been satisfied or not satisfied and why. So it makes it easier for staff to write up the DNO because it has to be contained in the DNO. It's the Supreme Court doesn't give you any leeway on that. Now I want to talk about the now Waiha 2 case. Okay.
So then, practically speaking, where is this analysis? Is it part of the EIS? Is it a separate thing that says Kapakakai analysis? Where do we see this?
Yeah. On a DBA, a newly initiated proceeding, it should be contained in the EIS. I mean, chapter 343 requires that type of analysis. So if there has been a recent EIS done that is adequate, and we don't know that sometimes until we have a hearing on it, then the information in the EIS can be used to satisfy the Kapakai requirements.
So that doesn't necessarily will be pointed out as Kapalkai analysis.
No, what usually, I mean, more recently, because of the recent Supreme Court case decisions, you will have an attorney for the petitioner represent that they've gone through the Kapakai analysis and they'll explain it. But traditionally, what we just got was the cultural resource assessment, the impacts, and then we had to render a decision, not specifically talking about Kapakai, but they had to give us that information so that we could move forward.
Mr.
When did this take place as far as I guess inserting the Kapa'akai?
Well, the concept has been around since Waihole, which was 2000 or earlier even, and it's contained in the Constitution. But the courts have interpreted time and time again and given us more guidance on it, but it's always been there.
So the date will be, what date you said? 20? When was
The
it?
the court cites it at 2000.
2000, Waihole was 2000.
Thank you.
One second.
Any more questions before I move on?
So does somebody, does somebody on staff actually give us guidance and do the review for us, or is it?
Yeah.
So somebody, you know
Well, what we will do is we will point to evidence in the record before going into a hearing in our staff report that helps to satisfy the Kapakai analysis. But that doesn't mean our staff reports aren't the be all and the end all, as I pointed out a couple of times. We've gone into hearings thinking that, everything was fine. Our staff reports indicate everything was fine. And then we get public testimony that, hey, my family's been throwing net down there for 40 years, or 40 generations, and none more, nobody talked to us. So that's why we always caution that the staff reports are our take on what's happening going in. You never know what's going to happen in a hearing. And if you get testimony like that, that indicates that the cultural resource assessment was inadequate, or that there are other issues that were not touched upon that are associated with Kapakai, then what staff has told you before doesn't mean anything.
So Commissioner Hayashida, so as a general rule, a petitioner is encouraged to bring forth the person or the company that performed their Kapakai analyses as an expert witness during the evidentiary hearing. And the commissioner and the other parties get an opportunity to question and follow up directly with the entity that did that. It's also not uncommon that if members of the general public take issue that perhaps the analysis was incomplete or had flaws in it, that type of testimony also comes forth before the commission during the evidentiary portion of the hearing. So ultimately, we have to weigh what the experts are saying and what the community is saying, and then make the judgment call. But a lot of that just kind of unfolds in front of the commission in live action. But in addition to and in preparation for the live action hearing, evidentiary hearing, we do get the staff report, and sometimes we'll actually see as part of the EIS or even a standalone document that represents the analysis that was done.
Yeah, I think you have to remember that the staff reports are based on the stuff that's been filed already. What happens in the hearing could be completely different.
Can I add one quick comment? This is Dan Morris.
Go ahead.
One comment I had is that Chapter 343, Hawaii's version, it's called HEPA, Hawaii's Environmental Protection Act. It requires, one of the things you have to do is to look at cultural impacts. And that's why those types of statements help in the Kapakai analysis. But looking at cultural impacts is really not the identical thing as considering those three components that have to show up in the findings that the commission comes up with. So it is useful and it may cover the whole issue, but it's not really structured or sort of framed exactly the same.
That is correct. It's an EIS very often has a lot of the information necessary for us to perform a Kapaka analysis, but it may not have everything. And it's up to the petitioner to bring it forward. This has become very controversial. And I'll go into that in the discussion of the Nawaeha case.
Turn it off. So when they're coming in with amendments, are we seeing some of these older projects that didn't have this analysis done? Are you seeing in the amendments that these analysis can be required or added on to?
They should be. I mean, the recent Supreme Court case decisions indicate that every time we make any type of decision, no matter what it is, we have to do a Kapaka analysis. So if they haven't done one, if they come in for a motion to amend, for instance, and they haven't done a Kapaka analysis, or they can't point to where one has been done, we can't move forward. Okay.
Yeah, let me also say by example, generic example, if we get an EIS in which the commission feels that the traffic study was inadequate, that's a similar judgment we could make to say, we don't feel that the EIS is, that we can accept it. And we want you to do an updated traffic study as part of the EIS and send it back for further work.
Yeah. And that's not uncommon either.
Not uncommon. Commissioner Lee.
Following up on Commissioner Hayashida's question then, so if a status update comes up and that petitioner had not done a Kapakai analysis before, would that be something that would be brought up?
It can be. I mean, we're not taking action usually we're not taking action at a status report. The only action that we would potentially take would to be file a motion for order to show cause, which is sort of, we're protecting that. But
Well, I'm not just saying that in case we have another lawyer that's similar to a previous one that likes to bring that up and would want to bring that up at any opportunity. So that would not be something that would routinely be required as from an annual status update.
no. Usually our status updates are associated with the conditions that we've already placed on the project. If the petitioner was to file a motion to amend, I think they would probably have to do a Kapakai analysis. But just telling us what they're doing, they don't have to do it. Because theoretically, it was done when we issued our decision the first time. So.
Commissioner Yamani.
Just wanted to clarify the Kapakai framework applies to all Hawaii boards and commission, not just land use.
That is correct.
But the case was brought in front of a land use decision.
The Kapakai analysis came out of a case in front of the Land Use Commission.
And then I guess I just wanted to clarify Chair Giovanni's commission doing the Kapakai analysis, the petitioners doing the Kapakai analysis. It's not really explicit, like you said, it can be in the EIS, all the three factors, but not listed as Kapakai. So is that what you mean by saying that we need to look at those three things from our commission standpoint?
Yeah.
And so, okay, that one is met, that one is met.
Yeah.
But in the EIS, it doesn't say this is our Kapakai analysis. So that maybe that's why you keep referring to saying the commission does the analysis, but it's the petitioner that does all the legwork on these three factors.
The commissioner does the analysis based on the information that the evidentiary information.
So it might not be pointed out as Kapakai. That's why it's for us staff to say, hey, keep that in mind on the Kapakai.
Yeah.
Okay, thanks.
And staff will, if we think that there's a problem and the analysis is inadequate or hasn't been done, we'll let you know. But you do have to keep that in mind, that the Kapaka analysis needs to be done and satisfied.
Dan, just so you guys know that the consultants and the legal representatives out there understand a lot more about Kapaka now. So it's not uncommon that you will see a Kapaka analysis included in an EIS or an EA and a petition or even motions to amend. And we do discuss this when we talk to the consultants or the legal reps of petitioners who are attempting to bring things before us. So we do mention, hey, look, Kapaka analysis is one of the things that's going to have to be addressed. How are you doing that? Make sure you do that. Make sure you cover all the bases so that then the commission can, in effect, render a decision.
Okay. Now it sort of took this one step further, and I'll explain that as we go through it. First of all, the evidentiary requirement, the promise of preserving and protecting customary and traditional rights would be illusory absent findings on the extent of their exercise, their impairment, and the feasibility of their protection. So that's reiterating Kapaka, even though it doesn't use that language. All parts of the Kapaka analysis must be fully represented by the facts and contained in the decision order through specific findings and conclusions to avoid appeal. And once again, this is a reiteration of some of the stuff that we've already talked about, but the courts were a little more precise with what they were saying in the Now VIII decision. Any balancing act between public and private purposes begins with a presumption in favor of public use, access, and enjoyment. That comes from the VIII case, and what they're saying there is, once again, that public protection of the public trust trumps economic resource, economics, basically. Even if the project has economic benefit, it's going to destroy a public trust resource. It doesn't meet the criteria. There's a higher level of scrutiny with regard to private commercial uses. So almost everything that comes in front of us is a private commercial use. So that would mean we have that elevated standard. The burden ultimately lies with those seeking or approving such uses to justify them considering the purposes protected by the trust. And once again, that goes back to the fact that the parties have to present their case with regard to Kapaka. Burden of proof is on the applicant. Besides advocating the social and economic utility of their proposed uses, permit applicants must also demonstrate the absence of practicable mitigation measures. That's a little confusing. And if this is a little bit new because the Kapaka analysis actually asks for mitigation measures, the proposed mitigation measures. If there are no mitigation measures possible, the applicant has to reveal that. And then the commission has to decide whether or not the action, absent some form of mitigation, is going to destroy the public trust resource. Okay. It's intrinsic to the public trust and the definition of reasonable and beneficial. Decision makers must not approve applications with minimal scrutiny. In other words, you can't let somebody come in and say, oh yeah, we did it, it's fine. I mean, you have to push them on this. There's an affirmative duty on the part of the commission to dig into this stuff. They can't just pass it off. They must take the initiative to gather information before it acts. So if you have any questions about what's happening, you need to ask it and you need to let us know. This is difficult for staff. Okay, this case surrounded a Commission on Water Resource Management decision. And the Commission on Water Resource Management is different from us because they have hydrologists, geologists, all the rest of those guys on board who do an analysis of the impact of the proposed action on the water resource. We don't have that. So this affirmative duty places a burden on staff to think about not just what's been presented to us, but what hasn't been presented to us, which is the next step. And this is new, right? Because before we were just looking at what came in, and is there anything that comes up at hearing that would implicate the public trust doctrine issue? Now, because of this affirmative duty, we have to go beyond what's on the record and say, look, staff will point out, we think this actually implicates such and such, and there's no evidence on the record with regard to whether or not this project is or is not going to implicate that resource. So it's made it harder for us, staff, and we may miss something. So you as commissioners need to think one step ahead. If there's not definitive evidence on a public trust doctrine, public trust resource, the commission cannot render an approving decision. And once again, that doesn't mean you have to deny, but it may mean that, hey, look, we think there's going to be an impact on the limo gathering below this project. And you didn't talk about it. Go back and do a study on it. So you don't have to have the answer, but you can make them go and get the answer.
Yeah, I want to comment on that.
Yeah.
You know, I mean, the reality is we don't know what we don't know, and we can't be expected to know what we don't know. But there is a way that kind of unfolds in front of us that helps us. And that's through the community or the public testimony that comes before us. So oftentimes the public testimony, and especially in a controversial petition before us, the public testimony will raise public trust issues that may or may not be included in what's presented by the petitioner as part of their Kapaa assessment. That's an opportunity where we as commissioners can say, hey, this one was brought up, you did not address it. We think it's real, or at least deserves some further investigation, and we're going to send it back to you to do that.
Okay. Not quite correct. In this case, the Supreme Court kind of called bullshit on that.
How's that?
Okay, and
So they're saying I'm supposed to know what I don't know?
yeah,
I don't agree.
that what the Supreme Court said in the specific situation was, okay, so one of the issues was the restoration of water to the streams in Lahaina. Okay. Because they'd been dry for a century.
Yeah.
So what the Supreme Court said was, you have to restore the natural flow in those streams to determine whether or not there could be or would be cultural gathering practices taking place in those streams before you can complete your analysis.
I think that's reasonable. I don't think that falls into my category.
Well, the argument that the Commission on Water Resource Management was making is that we don't know. You know, what are we supposed to stop and not do anything? And the Supreme Court said, yeah, you're supposed to stop until you restore the stream flows.
Yeah, so let's continue this hypothetical.
Yeah.
So if there's a dry stream bed,
Mm-hmm.
there, in my mind, there is definitely a consultant out there that will address the question for you. What do you think might be the practices that would occur if this stream is at full flow?
Yeah, but what the Supreme Court was actually saying was that you don't know if the heave-high are going to come back, if the shrimp are going to come back, or
Yeah, but somebody will speculate on that, and then you can make a judgment call.
Yeah, but
They're just saying, in my mind, what they're saying is you can't ignore it.
what they actually said was you have to restore the streams first before you can make a decision.
You have to restore the stream in the water case.
Mm-hmm.
So you have to do a practical experiment to.
Nobody knows. I mean, this decision just came out a month ago.
Okay, fine.
Yeah.
Enough of this. I want to move forward. Okay.
I mean, I'm not saying I agree with this. I'm just telling you, this is what the Supreme Court said. I mean, from a practical standpoint, it causes a lot of problems. What's even more disconcerting for most of the development community is that the principle used to be that if you had a water allocation, say for a golf course, and then there was a designation of water for other uses, you were guaranteed that water. You still had that because it had been given to you prior, you had that allocation. And the Supreme Court said, no, you can lose your water. If your utilization of water for a golf course is going to impact water needed or reduce the amount of water needed for cultural resources and practices, then yeah, you can lose your water.
Yeah.
So that was new too, and it has the development community quite upset, but that's what the Supreme Court said.
Okay.
One of the other things, I mean, we talked about Article 12, Section 7, which is sort of a further reiteration of the protection of cultural resources. But one of the other things that to keep in mind is that obligation is not delegable.
Not what?
Delegable. The commission must affirmatively act to protect the resources, not delegate the responsibility to a private party via a condition instructing them to generally protect the resource. In other words, you can't say, well, okay, we'll grant your petition, but we don't know if what you're doing is enough to protect the resource. So we're going to leave it up to you to protect it. You cannot do that. We cannot craft a condition that puts the onus on a developer or a petitioner to protect the resource. We can craft conditions that forces the petitioner to take action under certain circumstances. One of the best examples of that is the standard condition that we always put in about if they find bones, they have to stop and all the rest of that stuff. But we can't leave it up to them to figure out how to do it. Okay.
2 more slides and we'll take a break.
Or you can go on to the next slide. The overall impact of the decision is that there is an affirmative obligation to develop evidence on the impact on the resources. It is further expanded. In other words, that affirmative obligation is further expanded. The streams had to be turned to a natural state. This, as we were just talking about, places somewhat of a speculative obligation on the agencies. Cultural practices are prioritized as well as environmental. If there is anything left of the resource after, then the next priority is agriculture, then after those resources are protected. Then residential or public, with the bottom being things like golf courses and recreational uses. And that is, we also would refer you to the recording that we have of our former chair, who actually teaches a course on public trust at the university for your review. I think it's valuable and very helpful.
Commissioner Umani.
What brought about the Kapolei versus Land Use Commission? What did the Land Use Commission do that? You want me to talk to that? It goes back to that snippet of the obligation is not delegable. That's really the crux of that decision. The Land Use Commission approved a development project on the Big Island, and they basically put in a condition that said, okay, developer, you need to create a cultural resource group and find out what they think, about what are the traditional customary practices that have been occurring or want to occur and how they might be addressed. We basically delegated that authority to the developer. The developer didn't balk at it. The developer actually never really put anything meaningful together.
Who appealed?
Yeah, Kapolei Okaina, a group that came up around that specific issue. I mean, it was practitioners and people within the community who had used those lands for generations.
Martina,
And they built a cultural center, by the way.
yeah, Martina, do you want to say anything?
It had to do with the salt ponds and activity in the salt ponds near the petition area specifically.
Very good. I also want to hearken back a couple weeks to the presentation that was made to us by the folks from the water area. And I think it underscores the importance of what, came out of that presentation was a willingness for a direct relationship between Seaworm and the LUC. That if we get a petition before us that has water issues, we can refer to them, questions directly to them, or staff can refer issues to them directly for them to weigh in on directly back to us to help us do our job, as opposed to what kind of was the state before, that it had to kind of go through OPSD to water and then back and then to us. So I think where we landed was it's kind of a three-way, that if there are water issues, and a lot of this public trust stuff goes to water issues, they can be more intimately involved in our work, and including OPSD. So that's a good thing, I think.
Yeah, there are several ways that we can get their involvement at a hearing. One of them is to ask OPSD to call them as a witness. I mean, we can do that, staff can do that ahead of time, or if during the hearing, the commissioners feel that they need Commissioner Water Resource Management's input, we can ask OPSD to call them as a witness. The other way we can do it is to subpoena them. But we would rather have OPSD call them as a witness.
I think a phone call's better.
Yeah. So,
I do want to point out, though, just to remind you that OPSD has the statutory authority and responsibility, both under Chapter 205 and under their own creation document, Chapter 225M.
225.
Yeah, their responsibility is to present the state's, the broad state.
Understood, but
And that includes, that includes with Seaworm, so.
yeah, not bypassing them, but I just I think the commission is well advised that if we perceive there are water issues on the matter before us, that we make the effort to make sure they get involved.
Absolutely, and generally staff does that by trying to discuss that with OPSD to make sure that, hey.
Yeah, but now you've got an opportunity. I don't think you were there at this meeting, were you?
I wasn't there, but I was
It
part of
ended
what
with a willingness for a two-party.
generated that.
We can, okay.
Yeah,
We're good.
absolutely. If in the absence of other state, representation of that interest, we will directly respond and request Seaworm's participation.
Okay, good enough. Commissioner Carsmith?
I have an odd question, but I'm wondering who wrote our training materials on public trust. Was it you or the AG's office or Jonathan Schroyer or?
A combination of all of us.
And some quotes are taken directly from
Yeah.
court
I mean,
cases.
the only thing
Yeah,
that they didn't
I could
involve.
tell the quotes, but then, and after that, you guys would insert some statements about what we should do, and I'm pretty sure that's not a quote, but it's somebody's interpretation of what we should and shouldn't do, and so I was just curious.
Which slide? Which slide are you referring to for the quote?
For example, 105. Just an example.
I have it on the screen.
I'm assuming that's not a quote from.
No, it's a paraphrase.
Yeah.
I mean, and a lot of these
And
things.
this is when somebody is telling us what must be.
I mean, a lot of these are paraphrased because the actual verbiage would take 5 slides,
I understand.
yeah.
I just think, you guys need to be careful about what you're providing us and Where's it coming from?
We get a lot of advice on the public trust doctrine. I mean, it comes to us constantly from various sources. It is a combination of interpretation of the cases by staff, as well as interpretation by former commissioners, as well as interpretation by the Attorney General's office and how we've been advised. I mean, I don't think that any of the statements that are made in this section are challengeable.
Commissioner Ugu.
Yeah, and I just wanted to bring up a point, and I can see why it's important, Kapaka'i, especially in the 2000s when this came about, yeah? But as we enter 2025, I don't want to be reactive. And I feel even Kapaka'i is reactive because maybe what we lost from the 80s, the 90s, the going to the beach, collecting the limos, certain limos. We can break them down with a bunch of limos, right? We can do so much, right? Because we lost a lot. And at the current present time, we're losing our residents. So that when you're saying, or you cannot be an umpire, make the decisions based on, I guess, economic decisions. But the economic impact hits the Hawaiians first. We're the first to leave. Let's make that point out. Because I don't want to be here in 2050 when Kapaka'i now adds, hey, how we keep our residents on island? Because I think that is the most precious resource that we have. Because it's missing and it's lacking in your document about humans. Lahaina lost homes and they are out migrating faster than we ever saw. And it's missing in your documents. And again, we are reactive and not proactive. And I'm not disagreeing with what you got up there. I'm saying we're missing a valuable component. When I was on the Cultural Resource Commission, CRC, they used to say, oh guys, we got to keep the houses intact to have the look of Lahaina. That was the intent in certain areas, historic districts, right? But what they missed it's not the house, it's the person within the house. So if you can protect lands that is now not with the Hawaiians on top of it, who are we protecting them from? When you talk about generations, I like to be specific on what generation you're talking about, because our generation is leaving. If we saving it for future, you tell me who the future is at this current trend. It's not my grandkids. I got 10 of them. So I want to be specific and who we doing and who we saving them for, because it's missing in your document. I got to put that on writing, and I don't disagree because I agree with the trust. I agree with the water resources. Just to let you know, I get cousins who raise kalo for a living. I go to the beach. I'm born and raised next to the beach. I'm all for it. But we got to take in all impacts that affect Hawaiian people. And that comes with economic impacts also. So that's my 2 cents. So I just say,
Yeah,
no need to respond.
yeah, well,
We're running out of time.
Okay. It is very controversial and there is a lot of argument about it. What we've done here is we presented you with the information that comes from the Supreme Court as to how we're supposed to behave. And
again, it's reactive. That's what I'm saying, to a certain degree.
the courts, I mean, we don't, it's the law of the land, right? We can't get around it. The court, that argument was made by one of the petitioners in Kapaka'i, not Kapaka'i, in the latest decision. And the courts they actually made a specific statement with regard to that. And what they said was that if the idea is to protect the Native Hawaiian culture, if you don't protect the resources by which they practice their culture, then you don't have a culture. I mean, it said that in the decision. I understand exactly what you're saying. Yeah, I understand exactly what you're saying. But if we don't follow these Supreme Court decisions, we run the risk of being overturned.
So I want to add my 2 cents on top of Commissioner Ugu. First of all, I really appreciate you making that statement that you did, Commissioner. I find more often than not that we're living with interpretations and decisions of historical policy that is out of sync with reality today and that are in dire need of some revision and updating. That's a process that has to occur in its own natural state. But the reality is we're caught in a vice where the Supreme Court is interpreting things from a bygone era or a bygone days or a bygone time they're written in a different context. It's contextual. And I would not be surprised. I mean, I can't foresee it, but I would not be surprised if there's a new generation of policy and laws that come forth as a result of the current context that Commissioner Wu so clearly articulated, and I thank him for. Commissioner Lee.
Yeah, I just want to chime in on this because if we look at slide 110, the first paragraph, the last word is feasible, and then if you go to the next slide 111, the last paragraph, the second word is feasible, and I think that even Supreme Court justices evolve and change. And so I don't know that some of the stuff is gospel that will forever be true. And so that's what I think Commissioner Nancy Carr Smith was saying is that, yeah, some of what we got from previous commissioners and maybe, current state of thinking may or may not actually hold as things change, as more local people get pushed out. Who are we saving the water and the resources for if all the Hawaiians have to leave? So that might change the calculus of some of these decisions.
I don't disagree with you. I think that that's one of the problems with the current constitution. Chair Giovanni and I were having a discussion about that. I mean, last constitutional convention was in the 70s. Things have changed a lot since then. And that's what the Supreme Court is interpreting is the Constitution. So
even feasible is a judgment call, right? So,
well, the feasible in this section refers to that's actually a protective word because what they're saying is you can't force a petitioner to do something that is
not feasible,
prohibitively expensive,
right?
To protect the resource. So
even in the state constitution, it talks about balancing the needs, economic, cultural, environmental. One is not higher than the other necessarily.
I'm not a Hawaii constitutional scholar. The only thing that we're pointing out is what the Supreme Court has said and what we've got to live with. I mean, I don't disagree with Commissioner Uu or yourself or Commissioner Giovanni that, we got to build some houses, to keep people here. But if we do it outside in conflict with the Kapa'akai analysis that's required and the constitutional provisions that are required, we run the risk that we will be appealed from.
This is Dan Morris. I wanted to just make one quick comment. I thought it was a very good comment about this balancing. The Constitution does talk about balancing protection of the resources with private development and so on. So that is a definite component of the constitutional analysis. I do note on slide 114, there's a comment from Navai Eha 2, which I haven't read myself, but it looks like a quote that says, any balancing between public and private purpose begins with a presumption in favor of public use, access, and enjoyment. And so that sort of suggests that, yeah, you got to balance, but you sort of start with this presumption. But that doesn't take away the fact that there is a balancing process. So I don't think you have to feel like your hands are tied in every decision to, force you to decide a certain way without going through that balancing process.
On that, Commissioner Wu,
Thank you.
is that the comment? On that note, We'll take a recess. To come back 11:15. Microphone is on and I'm on and it's 11:14 and come back a minute early.
Okay, we're gonna jump to sustainability and then come back to ethics later on. We thought good segue from public trust to sustainability. So Martina's gonna do that.
Great. Tina?
Yep. So since we were talking about basically sustainable practices in the public trust section, that's why we skipped over a little bit. But the Land Use Commission does have requirements to consider sustainable practices, and that relates to climate change and other natural resource management. And that's in Hawaii Admin Rules 1515, and it's also in our statutory requirements. Yeah. Oh, wait, can you go back? And then, sorry, the image on the right is actually of the state's Hawaii Sustainability Plan, and that was conducted in the Office of Planning and Sustainable Development's Sustainability Branch Program. And if you want to take a look at that, it's really interesting. It lays out the UN goals and lays them out to state initiatives and laws. And it breaks out everything from housing to energy components and food requirements.
Yeah, I think that, if I may interrupt my section, Martina, the fact that, it's contained in 226, 108, and 109 were the sustainability requirements. And the sustainability plan, where all state agencies are actually mandated to adhere to that plan and those requirements. So this is not something that we just decided we wanted to do. It's something that we're supposed to do.
And specifically, if you look at 226-108, there are 7 guidelines and principles that kind of guide those sustainable principles that we have to look at. And if you look at specifically number 1, it encourages balanced economic, social, and community and environmental priorities, which automatically incorporates the public trust and those economic values that we hold so dear. And in 5, actually, all of those 7 are really crucial to balancing the things that the state needs the most to make communities strong and keep local people here. And in 226-109, that's specific to the climate change and adaptation priorities, which are components of EIS and EAs that we as the Land Use Commission and Land Use Commission staff have to look at when we are looking at DBAs and other motions in front of us. And that has to do with, sorry, where was I? Balancing and preserving the natural with the built environment. So like coral reef protection and watershed mitigation and yeah. Next slide. And components that we see specific to sustainability are solar, wind, and renewable projects. That we get those a lot in the forms of special permits. And we also get a lot of sustainable issues and principles arise through motions to amended DBAs. So we've seen projects that promote sustainability through energy components. So like housing with solar panels. And that's something that you as commissioners need to keep into account when you're considering things in front of you.
Thank you, Martina. I think the one thing I would add to that list for consideration, because as part of our administrative rules for LUC, we are obligated to consider climate change and global warming effects. And the way that I've seen it also come into play is that projects that eliminate green space and eliminate trees and things, we're always asking the developer, what are you doing on balance? So are you creating a park? Are you planting a tree in a different place? That sort of things. That's a way we can make
Yes,
it work.
exactly, because of the interactions with the built and natural environment. You have to consider those factors like the green spaces as well as climate change. So a thing that also comes in front of the commission frequently, which has been mentioned, is the impacts of climate change on water resources. And that's just another thing that the commission has to balance in their decision-making process, because as climate change is a known problem, it adds and stresses the water use across the state.
Thank you.
A section of our rules that requires discussion by the petitioner of sustainability measures is 15-15-50. Let me see if I got this. I think it's A24. No, B20, C24.
The one on the screen.
Yeah, and if you look at that, the way it's worded is that they just need to present us with information with regard to the impacts on sustainability. It is not a, so to speak, a decision-making criteria. In other words, if their carbon footprint is bad, it's not a reason to reject the project. But it does, we're supposed to be collecting the information and encouraging the petitioners to adhere to the sustainability plan.
Well, okay, so chapter 226, which is being referenced, 226, 108, and 109, that's the state plan. That is one of the things that you have to consider in your decision-making criteria under chapter 205-17, Land Use Commission decision-making criteria. So the state plan, these are components of it. You have to take this into account when you make your decisions. So you need the information provided to you to be able to take it into account.
Yeah, that's interesting you brought that up, Scott, because at the last meeting with CWORM and OPSD, they kind of said there was no state plan. And I don't know if you were there.
They are incorrect,
Yes, that's what I thought.
politely speaking. He knew I was rolling my eyes.
Oh, you
where hard
I
it
should have
was.
said something then.
I think
It was their presentation.
I think what they may have been alluding to was not the state plan itself, but the functional plans that are a component of the state plan, because the functional plans have not been updated in many cases for many decades.
Mr. Carsman.
So I assume that staff, when looking at a petition, will review 226, 108, and 109.
Yes.
And
but
then when
it's
you,
it's not for us as staff to review 106 and or 108 and 109 and provide you with information about it if the petitioner or OPSD or the county have not provided evidence into the record on that. We may point out that, hey, there's nothing on the record to this point to address these issues. And we suggest the commission specifically question
right,
the petitioner and or a witness and or the county or the state.
that's what I was getting at.
Yeah,
So in your report, you would mention that because these are pretty general statements. Actually, so I
They're-
can't imagine.
Yes.
They do provide a good amount of latitude for a petitioner or other entity to provide you with information that they believe meets the requirements.
Thank you.
It'll be up to you to judge whether or not that's sufficient, credible.
This is also an opportunity for me to talk a little bit about what actually happened. Staff doesn't just take in all this information and then blindside a petitioner if they're missing something. If we go through a petition or the documents that have been filed and we see something that's missing, we'll call up a petitioner and say, hey, look, we're keying in the commissioners to the fact that you didn't cover this in your documents. So you better be prepared to answer it at hand. So it's not like they're blindsided when they come in. We talk to them about the deficiencies that we're seeing so that they're prepared when they come in with the information they need to, add to the record.
We also do that during the environmental review period. So before we get the final drafts of EAs and EISs, we look at those components that are necessary. And if we see something missing, like, for example, 5 and 226-109, if they don't specifically include information about how the reef and watersheds are impacted through the cultural or coastal zone management act, we'll point out that there's a deficiency and then they'll have to address that when they finalize their environmental impact statement and assessment.
But so, just so you know, we actually take a proactive reach out, and we do work with petitioners often very closely. And there are many instances where they have asked us, can we send you a preliminary draft before we actually send this in officially? And we don't like to do that, but we know that that's oftentimes useful. And so we usually make sure, okay, if you're going to do that, let us know ahead of time. Make sure that we have staff resources that we can actually review your documents and give you a cursory analysis. But also, we try to encourage them to do that with Office of Planning as well as the county. And, that way they make sure that when they do file something, that it's complete. It covers all the bases. We might not agree with the analysis they specifically do, but the main thing is we want to make sure you've provided information in all the areas that are necessary. Then it's going to be up to, staff to look at that analysis, but also up to the commission to identify whether or not they find that evidence credible and whether it's a preponderance of evidence, whether it's sufficient.
Proceed to the ethics board.
Yeah, and there's only a couple of things I'm going to talk about in here because we all got, well, except for Ken, we all got trained on the ethics by the Ethics Commission. And the only things that I'm going to touch on are some reminders and something that Robert brought up with me after the discussion we had the other day. Commissioners have to take ethics training every 4 years. You're also responsible to file your financial disclosures annually. Yeah. No carryovers. We already talked about communication, so we can skip that slide. Reporting and recusal. And this is more of a function sort of discussion. If a commissioner, pursuant to the discussion we had earlier about ex parte communications, engages in an ex parte communication, they should let the staff know right away, and they should disclose it at the hearing. Depending on the nature of the communication, the commissioner may need to recuse themselves from further participation. Sometimes that's a judgment call on the part of the commissioner themselves, and they may choose to recuse themselves based on the communication. Other times, once a commissioner has made a disclosure about an ex parte communication, the chair will then ask the parties if they have any objection to the commissioner continuing to participate in the proceedings. By the way, again, you feel free to disagree with me on this, but our advice in the past with regard to recusal is that if you choose to recuse yourself, you have to leave the room. You can't even sit and watch. So
Why?
so you know. I don't know why, but that's what we've been told, to be honest with you. I think that the go ahead, Dan.
Surely.
Yeah, I think that there was a court case where someone's facial anguish or, expressions might have influenced others. But I had a question for Deputy Morris on recusal. If someone had heard Waimanalo Gulch on the County Planning Commission, are they automatically disqualified from participating when it comes before the Land Use Commission? And what is the principle on that?
So the question is whether someone who was on a county council that handled a particular matter that's going to come before the commission, and then they leave the council and they're on the commission, and should they recuse? Is that the question?
That's correct.
Well, one principle is that the AG's office represents the commission. A decision whether or not to recuse is an individual decision that the deputy AG advising the commission can't really give guidance to the individual. So sometimes there's been situations where they'll be in a meeting and something will come up, and a board member or a commission member realizes they know somebody or were involved somehow, or their wife is involved, and they'll say, "Oh, deputy AG, should I recuse?" And that's not, in this particular context, an appropriate question for the deputy AG. So it's a personal decision, but that doesn't mean that in our training here, you can ask me for, well, would that be a basis for recusal if, for example, a commissioner used to be on the county council and is addressing a matter? I probably would have to look at the ethics code, and there is the State Ethics Commission that is also, like the OIP, willing to give advice to individuals about that. So I guess I'm going to add that to the list of things to get back to you on, whether that would be an automatic recusal or whether it would depend on the age of the involvement or the status of the matter or the circumstances in front of you at that time.
Thank you, Deputy Morris. I asked that because I've always heard that stated informally, that if you participated, and now we have 5 people here who have served on county planning commissions. And, so I was curious as to where was that a hard and fast rule, or was that something that the parties would, could opine on? So yeah, I'd appreciate knowing that, because we might have quorum issues or other issues with something like that, because I've heard that before, saying that if you participate on the county level, then you can't participate here, but I've never really heard any hard reason or where that came from. So,
No, it's a fair question and a good one.
So I have my own opinion on it. I'm going to stand silent for right now. But I'd like to request that the executive commissioner reach out to Robert at the Ethics Commission and ask that specific question if you've not already done so.
What Robert will probably tell me is that the commissioner involved needs to ask the question because their opinions are.
Well, we have 5 commissioners who have served on.
I understand, but
You want me to reach out to
one of the commissioners needs to ask the question.
I'll ask that question if you can help me draft it or whatever.
Yeah,
And,
I'm more than happy to. But
Yeah.
Robert was very adamant that the commissioners, we are not going for
Pardon me?
their advice can often be confidential.
But it's not relative to a specific commissioner, it's generic. If I interpreted the question.
Yeah, I mean, I would just.
Fine.
Yeah.
So Commissioner Lee, would you, on behalf of this commission, reach out?
I'll do that, but if the executive officer can assist me in formulating the question, and then I will submit that to Mr. Harris. And
Yeah.
I'm curious because, we're gonna all do this de novo, right? All news, no matter what we did at the county. And I don't see how that's different from if Mahi Solar came one time before and then they had to pull out and then they come back to this same commission. How is that any different? So
I honestly don't know the answer. I mean, I can tell you that in some commissioners in the past would have taken the position that your participation at on another commission with regard to the same matter, would give rise to the conclusion that you had decided the case. Now, I'm not saying that that's what you're doing, but I'm just saying that that's been the argument by some
I
commissioners.
understand. I see, I would guess that that would be the argument, but I'm trying to get, Commissioner Hayashida not to squirm out of some future meetings, so.
Yeah, yeah, no, I would be more than happy to frame that question, because I actually did ask Robert at one point, at the hearing the
Well,
other day.
is this a question that we need to find a way to get on the record?
Well, see, this is part of what Robert was telling me, because I asked him the question, and what his response to me was, well, I'll have the commissioner with the question contact us, because, sometimes
That's a generic question. If,
I understand what you're saying, Chair. I'm just telling you how Robert responded, because I asked him the generic question.
okay, so my follow-up question is whatever we get to resolve this, which is a communication between Commissioner Lee and Robert from the Ethics Commission, I want it to go on the record. So how do we get it on the record? Do I have to
Well-
agendize it as a topic or what?
No, I mean, when we go into the hearings on one of these matters, and there's going to be
I
plenty of
want
them.
to deal with it generic.
No, I understand.
Wouldn't there be an informal opinion that, Robert would issue?
He could issue a formal opinion. We could ask him for that. But, it's very easily handleable, Chair. And that is that the first time we have a hearing on one of these things, where one of the commissioners has sat on the planning commission, like, for instance, Wyman Gulch is coming up. And, then during the time when the chair is asking for disclosures, the commissioner would state that, I just want to disclose that I sat on the planning commission, and I questioned OIP with regard to my participation, and they gave me an opinion that it was fine for me to continue. And then you'll never have to ask the question again.
And then Deputy Morris could agree or disagree with that as well, correct?
Mr. Chair, follow up.
That question to Mr. Morris?
And so the question is, do I agree with Dan Orendenker's recital that when the matter comes up, the particular commissioner can state whether they make the disclosure about their prior participation and articulate on the record what their advice was?
No, that's not the question. The question is, you could disagree with OIP's opinion. Is that correct?
That's correct. If you sort of get guidance that, OIP says you ought to recuse, and you say, you know what, I don't think I should, the risk you run is that any decision that you made or a vote you take could potentially be challenged and affect the decision if ultimately a court later said, oh, you should have recused, so your vote isn't good, and so all of a sudden the action taken becomes challenged.
The inverse is also true, right? OIP said I could do it, and then you want to be safer and say no, you could disagree, correct?
And that way works a little better, like you don't have to, but in an abundance of caution, I'm going to. You really don't get into trouble that way.
Mr. Imani?
So I guess kind of leading to the disclosure during a hearing, even if a commissioner did disclose and got an opinion, I know the chair asked all parties if there are any objections. If one person objects, does that kind of shut that issue down no matter what the opinion is?
No, if there is an objection by a party to after disclosure, then it is up to the chair on whether or not to allow the commissioner to proceed. And he can ask the other commissioners how they feel about it. We can go into executive session and discuss it, but ultimately it is the chair's decision.
And here's a slide on disclosures.
Excuse me though, but if the chair goes against the intervener's objection, that's something that could be challenged in court too. So by the same principle of playing it safe that Deputy Morris said, that would be a dangerous thing for the chair to do. Isn't that correct?
What? Yes and no. I mean, sometimes objections are frivolous. I think I've talked about the Sierra Club instance, that's something that chair has to weigh. And And that's why it probably would end up in executive session so that the chair could get the advice of counsel as to whether or not this was if it wasn't appealed, would this be, would we win? How good is our position on this? And then render a decision.
Okay, so I'm going to disagree with executive officer on the process. And I'm going to ask Commissioner Lee to handle it generically with a generic question about to the Ethics Commission and to report back generically, because I don't want to deal with it on a case by case, commissioner by commissioner basis. Okay?
Should he ask for that in writing, Chair?
Yeah, I'd ask for a writing.
Yeah.
I'd ask for that opinion in Mr. Lee, if you don't mind, Commissioner Lee. And request that, I think it's simple, really. I don't think it's that complicated. I'd request an opinion on the generic question from ethics and report
Yeah.
it back to us.
And I want to
Then I want to get it on the record.
Yeah, I want to be clear, Mr. Chair. I wasn't suggesting that we would have to do it at every hearing that it came up. What I was saying was one time, and then we never have to deal with it.
Refer back to that one time every time it's precedent. Understand?
Can I just make a point though that, in you asking for that opinion, it's going to be an opinion to you. So what you'll have to do, and you perfectly have the right to say, I'm happy with disclosing that publicly. But
No,
but
no,
it's
it's a little different.
but it's up to him.
The chair is asking him to represent the commission and inquiring to the ethics.
Right, then if that's the case, if the opinion is to the commission,
It is.
then it's the commission is the client, the commission is the one that has to say, we're happy to make this public, whatever the opinion might be.
That's what I think. I think we have to put it on the record. That's what I meant by that.
Yeah, I think this issue will come up quite a bit. And so it would be
Deal with it proactively.
informative to even other boards, because I can see this coming up as well. So if EO will help me formulate that, and I'll sign off on it.
Yeah,
And-
I'm just, I understand what the chair is saying about wanting a generic answer, but I asked Robert and he said, well, no, an individual commissioner.
And also OIP may take a little bit of time to respond to,
Yeah.
right?
So we'll get to work on that right away.
I think he's at fault for not bringing it up when he had our meeting.
There's a couple of things that he didn't bring up that he talked to me about after the meeting.
Anything else?
Yeah. Well, okay, let's talk about, since we're on disclosures, let's talk about disclosures first and we'll get to the other. Disclosure of personal relationships or knowledge of those relationships, ensures transparency in the decision-making process. This is not an ethics code. As far as the ethics code is concerned, your only requirement is to recuse yourself or make disclosures when you have a financial interest, or your family has a financial interest, or your organization has a financial interest. This stems from our requirement to be transparent. And I have to say that in all the time that I've been working for the commission, I have never seen anybody have to recuse themselves because they said, oh, well, we used to go to Japan with them, with the attorney for a petitioner or whatever. It just adds to the transparency of the commission that you reveal all your relationships so that nobody can then come back and challenge us for failing to reserve those and to reveal those relationships on grounds of bias or impropriety. So it's not something to be concerned about, but it's something that aids in the transparency that's required of the commission. There is, and that goes to the next paragraph, personal relationships or knowledge of petitioners or a party representative may create conflicts of interest for a board or commission members. These conflicts could compromise the integrity of the decision-making process. That was what I was alluding to, that somebody could claim that the decision-making process has been compromised. And keep in mind that we're watched over closely by the press a lot of times. Civil Beat and the environmental report, Environment Hawaii, and they dig. So if, you have a relationship, it's better to just talk about it, just get it out of the way, and then we can move forward. It's about maintaining fairness, perception of fairness to the parties. And Hawaii is a small state. I mean, we all know, we know somebody, usually somebody who appears before us is somebody you might know. So it's easier to just disclose it. Lines that must not be crossed. And these are pretty self-evident. And Robert talked about them. Must not participate in proceeding that will result in a benefit to his or herself or their immediate family, not provide insider information, and no monetary gain. The other matter that Richard brought up with me after the discussion the other day is this one. And it's Ethics Commission Advisory Opinion number 2017-02. HRS section 84-14D prohibits a commissioner from representing an outside organization on the same matter in which a commissioner participates in the official role as a commissioner. In particular, this concerns legislation which the commission supports or opposes. And this language was drawn directly from that opinion. You may not lobby the legislature or the administration on behalf of an outside entity or assist in lobbying strategy for the entity, perform research to submit to the legislature on the entity's behalf, help to prepare written statements for the entity, or testify on behalf of the entity. And I know this is difficult for some of you guys. That doesn't prohibit you from lobbying on behalf of the commission, because you can do that, right? But if it's a matter that concerns the commission, if the legislation is a matter that concerns the commission, you cannot lobby on behalf of the organization that you represent.
Can you testify as a private citizen?
I would suspect that Robert would answer yes on that. He just referred me to this case, so I had to look it up. Actually, Scott looked it up. And I think that as a private citizen, there's a, what do you call it? It's a U.S. constitutional issue with regard to that. You're entitled as a private citizen.
Let me ask a clarifying question. When you use the word lobby, or when we are to interpret the word lobby in this slide, is that a registered lobbyist or just a general concept of
Lobbying.
lobbying? Which is it?
It's the general concept.
Okay.
The level you see in the legislature, segueing into that, the legislature, we have to ask for approval for our budget. We deal with them on legislation.
I'm sorry, but can you go back? Thank you. So, I mean, this is saying that you just said that we could lobby, or we could testify on behalf of the commission. And just to clarify, we would only do that if we had the approval of the commission and the chair. Yes?
Well, as a private citizen, you can lobby any way you want.
Well, I'm not going to go lobby and say I'm here on behalf of the land use commission unless the land use commission has agreed for me to do that.
Yeah, I was.
Yeah.
But if you go and
Just
say,
like we asked you to not testify on behalf of us without first asking us our opinion.
if you go to the legislature and say, I'm Commissioner Nancy Carsmith and I'm here as in my official capacity as a commissioner to testify on this matter, that's fine.
I would never do that unless the commission knew I was going
as
to.
long as it was consistent with the commission's position.
Thank you.
But if you disagree with the commission's position, you're welcome to go as a private citizen and make your statement. Okay. The LUC and the legislature, back to that, they do handle our budget. The legislature gives us our budget. There are two sort of rounds we have to go through. One is since we're part of the administration, we have to submit our proposed budget to the administration for approval. But as we all know, that's not the be all and the end all. If the administration doesn't agree with our budget, the legislators have the ability to add or subtract money from our budget in the end. Legislation we just talked about, we are instructed, the staff is instructed, I think we talked about this when we had the original discussion, to testify on certain measures. Our position will discuss with on those legislative matters will be discussed with the commission before we file any testimony. The commissioner relationships with the legislature are also kind of unique. In other words, you have to go through advise and consent. So you will get commissioners you will get legislators calling commissioners and asking, you said this and but that's just a fair warning. It doesn't happen often. And, but you can, the legislature, there's no restriction on the legislature on calling you up. So just be aware.
So while the slide is up here, I want to take this opportunity for a heads up to fellow commissioners on the question of budget. As you may know, or you should know, the Land Use Commission is part of DBED. Pardon me?
OPSD, we're actually.
Ultimately a DBED, right? So DBED has contacted me in the last 48 hours to advise that they'd like to go forward with some clarification and rules and guidance on how we budget for potential increases in compensation for the executive director as a distinct line item in the budget. So I'm getting clarification on that. The heads up is that at a future meeting, we're going to review that guidance and deal with it, as well as there might be some implications as opposed to the decision we made at our last meeting.
Yeah, I thank you for bringing that up and forwarding that on to me, that advice on to me. What they're asking for is that we identify the line item in the budget where the money is going to come from. And I can do that. I mean, that's not a problem. I don't think they're asking for a total review of the decision. I think they're just asking for.
Yeah, they're not asking for a review of the decision. They want to know where the money's coming from.
Yeah, they want to identify them.
And they want the budget to make that obvious on a going forward basis.
Mhm.
Right. But there's also some, I'm getting further clarification on it. Some question about our actual decision and recommendations. They're not questioning that. They just want to make sure that the full commission understands it in the context of this new guidance that we're getting, so that it's not an issue. So, and they want it on the record. They've made that clear to me. So that means it has to be part of part of a hearing. So I'm going to agendize that going forward. It's just a heads up. I think it's bureaucratic. I don't think it's controversial. But
yeah, and since we're on the topic, the budget every year contains salary increases, and all of the executive officers, there actually is a provision for percentage increases for executive officers that we haven't been utilizing. It's the same as, if not more than, bargaining unit 13. So we can make that adjustment in the contract as well and refer to that provision. But the Department of Budget and Finance, for every executive officer in the state, programs that increase in. So the concern is only if you go over that increase, and you have to identify where the funds are coming from.
I think they also identified they wanted a copy of the evaluations.
Yeah, we've
For
already
future
forwarded,
submittals.
we've already forwarded that.
Okay.
Okay, anything more on that? Okay. Um, lunchtime, well, I mean, it's noontime. We just got administrative stuff left to do and that's it.
This is Dan Morris. Can I follow up on a request that I was made to follow up on and take care of that right now briefly?
Go ahead, Dan.
Thank you. I had a question about whether the Sunshine Law prohibition on groups of people meeting about matters, board business, how that applied to perhaps a meeting with the governor or something. So under Hawaii Revised Statute 92-2.5, it's called permitted interaction of members. And under subsection F, there's a reference to discussions between the governor and one or more members of a board may be conducted in private without limitation or subsequent reporting, provided that the discussion does not relate to a matter over which a board is exercising its adjudicatory function. So that really narrows it. If it's a matter you're going to be deciding on a boundary amendment or something, well, that's your adjudicatory function, and it's not really something that you could go meet with the governor and talk with the governor about. So 92-2.5 is a useful statute that talks about some of those more specific situations. One of them is meeting maybe with a legislative group or a community group, and can you go and participate in discussions? And it sort of mentions that you can, but you have to report back to the members about what was discussed, and you certainly can't deliberate relating to a vote on the matter or something that's coming before the commission. So that's also in that same statutory section where you can learn about some of those specific situations that the legislature has laid out for you.
Thank you, Deputy Morris. I just appreciate you confirming what my belief was. And so I guess we can go forward if we wanted to talk to the governor about staffing and budget increases without prohibition. And I'm not going to ask you to follow up on this, but there are other issues, other ways that more than two people can meet in the context of a permitted interaction group. So just leave it at that.
Correct.
Yeah.
Thank you so much.
Well, if anybody wants to hear the story about how that whole thing came about, you could talk to me later. It's actually a really funny story. But what some of the provisions of that were designed to allow, for instance, if this commission wanted to go to a neighborhood board meeting and to see what the neighborhood board was doing, or a bunch of the commissioners, it allows you to do that, right? Because before, the commissioners, only one commissioner or two commissioners could go to a neighborhood board meeting or a county proceeding without violating sunshine law. Yeah, whatever. So that's where that came from. But thank you, Dan, for that advice. Yeah, I mean, the current issues thing is a 10-minute discussion at the most, depending on questions. And then I don't think Ariana's presentation with regard to administrative stuff should go fairly quickly.
Go.
Okay. Current issues, and let me do current issues. That's part of current issues, or it should have been part. Did we skip over the slide? No. Okay. Okay. Yeah. Okay. Okay. So affordable housing is, of course, a big, huge, and it's something that we've been trying to help alleviate. I mean, our goal is to help alleviate this problem. I know a lot of the discussion that we've had over the past 2 days are concern the restrictions that the board is under, or the commission is under, but that doesn't have anything to do with what our goals are. Those are just out there for the commissioners to understand how they need to think about making these decisions. It takes 10 years to obtain a permit, only outside of the EIS process, only 6 months at the most a year is our contribution to those 10 years. The rest of the time is at the county. And if you talk to developers, you'll hear that they're just bollocksed up at the county. I mean, we talked with Kiki Pua Dancel the other day from Lanai, and she was just putting out her hair at how long it was taking the county to get things done and issue their permits. One of the issues, of course, is sprawl. I mean, that's something that whether or not how we want to deal with that has gone up and down throughout the years, and there is some of the legislators believe that the Land Use Commission should knock down boundaries and that we should develop inside the urban boundaries before we allow any new sprawl. And then there are others who don't think that that's practicable. I don't think it's practical either, but so that's the conflict there. One of the things that we have discussions with the counties about is what is affordable housing. Under the state's definitions, it's all the way up to 140% of median. I don't believe that that's really affordable housing. It does serve a purpose. I mean, we have gap housing that we need to fill in, but that's, when we talk about affordable housing, that's not it. And I don't actually like the term affordable housing. I think that what we really want to talk about is workforce housing. Because when you talk about below the poverty line, that's a whole different set of bananas. And that's, you know, the feds and the state have programs to deal with that. How can now we stimulate affordable housing? And that's how we got to hiring. We are trying to stimulate affordable housing directly at this point by actually getting in the weeds and trying to work with developers to get these things done. Conflicting uses, that's always been a problem. You'll hear time and again about how we need to figure out how much land we need for preserve agriculture for food sustainability, how much land we need to preserve for energy production, and how much land we need for housing. I mean, those are just the three conflicting uses that are year after year are out there. We've already talked about natural resources and the public trust limitations. We have an initiative, which Scott has actually been handling, and now with Arnold's help, to identify housing that is not being built using the GIS program, so we have a map of it. I would refer you to a Civil Beat article that Dr. Scheuer wrote some time ago. I think it's a good discussion of what the commission is trying to accomplish and what the problems are. Take it for what it's worth. Next slide. Enforcement has become increasingly problematic. County enforced based on local policy concerns. This results sometimes in inconsistent decisions. What a condition actually means is it left up to the counties to interpret it after it leaves us. We're struggling in each decision to bring modern issues such as housing, food sustainability, controlling urbanization and climate change into the process. And that's it on the current issues, I believe.
What do you mean controlling urbanization? Isn't that in today's context, what does that mean?
Well, it goes back to the competing use discussion. You know, if you're going to preserve land for food sustainability, how much land do you need? How far out from the urban core do you want to go with housing? Because once the housing is there, it's never coming off, you know. And so you'll hear the agricultural community complain about that.
Yeah, well, my position is my personal position is that that's an old argument that's out of date. When in the context of preserving agricultural land per se, you know, going back to the Constitution, I mean, the housing crisis today in the state is real. And urban sprawl is not real today. It was real at some point.
Yeah, if you talk to Brian Miyamoto from the, agricultural. He represents the agriculture, Farm Bureau, thank you.
Yeah,
You know, what he'll tell you is that, yeah, sure, we need
I'll
housing.
say to disagree with me, he's not gonna tell me.
But what he'll tell you is that their position is that, you know, they're not opposed to more housing, but they believe that it should be controlled in the urban core. I mean, this is, like I said, you know, I'm just bringing forward these issues so that the commission understands that they're out there. It's up to you what position you want to take on them, but these are the things that you will hear, at hearings.
Fair enough. Commissioner Wu.
Yeah, I just wanted to add, because I know you said you talked to the developers and they said it's the county and, you know, Maui's small. So I talked to them too. And I think everybody has a responsibility to say that land use is not a problem. Will be kind of blind me personally, because everybody is a part of the process. And just for clarity, we get more state land use regulations in the nation than any state, my understanding. And I think we have a third more than second place. I think we're all part of that problem, that land use regulation issues, that whole process of housing. And I read the article, Jonathan Chiro, by the way. And my question to you, how much houses have he built? That's my question. So when I go back and look at people who read and discuss and kind of give you guidance, I got to make sure he did it before. So here's an engineer. Like if you get an engineering problem or issue, I talk to an engineer. I'm a carpenter. You need help? I can help you go vertical. He's an operator. But to have someone, I don't know if he did it, if he built housing or not. I see someone who did it, not write something about it. So it's just my preference on, because I read every article just about in Civil Beat on housing, or anywhere, right? State, any state. I just saying. So I give you a reference to a guy who tell me it's incredible read, good read. Don't get me wrong, but I rely on people who actually build homes.
Yeah, I don't disagree with you that building homes it makes a difference, actually doing it. I think that, one of the things that we have to be cognizant of is that all of the things that we've been trying to do so far have not resulted in an increase in housing. And I've had this conversation with legislators. We have to think of something different, because just pointing the finger and saying, oh, it's the county's fault, oh, it's the land use commission's fault. That's not really where the issues are. The issues are with other things.
But you just did. You said that it's not land use.
No, the 10 years. Yeah, yeah.
I just saying, like
10 years.
everybody's a part of the problem. If we piecemeal every segment of the process and everybody says it's not a problem, hence that's why we have the problem. My 2 cents. Thank you.
Sure, Miles.
You know, just looking at the title, current issues and food, you know, we have food sustainability, and you reference the Farm Bureau in the argument of keeping urban or housing strictly in urban. So my question is, do they have any data on lands that are dedicated and I guess a surplus or people waiting? Is there a need? Is there people waiting to use land for agricultural food growth? Is there a waiting list?
That's a very big discussion. And, there's a whole bunch of factors associated with that. It's kind of you go in a loop on that discussion, because I've had it with Brian, and part of there's a recognition that not enough people are asking to be farmers, you know, and or want to be farmers. They have trouble getting people who want to be farmers, or they used to have trouble getting people who want to be farmers. But on the other hand, there's not a lot of available land to farm, because a lot of the large landowners have taken it out of production and are not leasing it.
There
So,
you go.
Yeah, so it goes around in a
Yeah,
circle.
so Commissioner Nakasado, I think, raises a very important question. obviously, I think that my personal sentiments have come across the last 2 days. It's out of balance. That a lot of this agricultural land is being preserved and they're just letting wild grass grow on it. We've had 4 fires in the last week on Kauai in brush fires that almost threatened us in the same way that Lahaina was burned down. It's crazy.
Yeah.
And so, let me finish.
Okay.
And so I think that it's out of balance. Because these are, to me, in my mind, old arguments about preserving the agricultural land where we don't have a backlog of people clamoring to get access to that land to produce food, because we don't see it. Instead, we see grass growing wild.
I'm not trying to come up with an answer for this or to try and propose a policy. These are just a list of issues that have been before the commission for some time that we're just trying to make the commission aware of, that these will come up in public testimony. They may come up in testimony from the Department of Agriculture, and things like that. There are, in my mind, without a major paradigm shift, these are unsolvable problems. If we continue to act the way we've been acting as a state,
No, I think,
as a
I think
community.
as it boils down to us, the Land Use Commission, if we get a project that's proposed to us on agricultural land to a DBA to convert it to urban, and the Farm Bureau comes in and says, no, we need to preserve this for food production down the road. That's an argument they can make before us. We have to make a judgment call on the validity of that in our decision making. That's how it comes down.
Yeah, and that's exactly my point, is that these issues are going to come up. You make the best decision that you can based on the evidence that presented as to what the priorities are, because you're charged with doing that balancing. But this was really just intended to educate you on what the issues are that are flying around out there.
Or Smith?
Just briefly, sorry, this affordable housing slide just,
Let's go back one slide.
and no disrespect to whoever made the slide or anything like that, but practically each bullet point is kind of hard for me. Is it, you see the problem? Maybe it's turned down some projects that should have been approved. So I think we have to take some responsibility. We can't just say, no, it's not us. Okay. 10 years to obtain permitting. I mean, who says that? And which county is that? And how do we know that's true? We shouldn't be putting things up here like this in front of us unless this is true.
It is true. I mean,
So each county told you it takes 10 years.
No, the legislature did an analysis. They brought in developers and all of the county planning departments to talk about the process. And this is the conclusion that the legislature reached, is that after all of that analysis, is that it takes 10 years.
But at the same time,
Not every project,
petitioners
but the
come
averages.
before us, generally speaking, and we give them grief because they're taking so long. And this is proof that, each step takes a long time and it's expensive. I'm just saying, we're kind of doing a double-edged sword here. I think that this current commission is probably going to be more interested in actually getting affordable housing and other housing built than maybe previous ones did.
Another thing here is that it is totally false to say that the Land Use Commission denies projects. And all the time that I've been here, the only project that we've denied was Olawalo. Every other project has been approved. I can't think of another project in my time that's been denied.
If you want to go there. The project, the YO project in Kona, because the commission decided to not reconsider, not grant the reconsideration, whatever the terms are for that.
That's an approved project.
It's
They just
a
haven't- they
project for
haven't-
5-acre parcels. Yeah,
They haven't-
which is not appropriate per the CDP, per the general plan. That's not the place for 5-acre parcels.
Yes, that's, but
So
that's an
to
approved
me,
project.
that's how I look at it, that that was not approved to go forward in the next steps in order to,
No, that was an approved project. The difficulty that they were having was that they wanted to modify the project and they hadn't done background work necessary to have us approve that modification. It's an approved project. And just like any other petitioner who comes in and doesn't do a proper analysis of the impacts of the project, that project didn't go forward. But that project is not over. They just have to do what they need to do.
I'm gonna have to kind of disagree with that and agree with Commissioner Carr Smith, because that was a judgment call, whether to give them more time. The county was okay with it, OPSD was okay with it, but the commission itself voted against it 7-2. So it's not necessarily just because approving or not approving DBAs. There's all kinds of steps, motions to amend, conditions, all those things add up that can either help or hinder. And I think that's where Commissioner Carr Smith was coming from, is that every little decision inspires or degrades confidence in a project and in financing. So I just think that, those things all play as factors and are things that we can consider and have some influence in.
Let's go forward.
And this is all, it's pretty much self-explanatory. We operate under an extremely open process that requires us to consider a set of defined public policy concerns in making and well-supported decisions to support economic growth and protection of the state's most important assets. We are in this limited venue tasked with effectuating policy surrounding all of these things: infrastructure, open space and agricultural land, protecting cultural assets and rights, protecting the environment, supporting economic growth, encouraging sustainable development, promoting job growth, protecting watersheds, encouraging deliberate and sustainable growth. And that section, the only section that we have left is the administrative section. And if you want to continue on, we can do that, or we can stop for lunch.
No, let's go.
Okay, Ariana, you're on.
Sorry, commissioners, I'll take everybody has an objection to continuing. No, go.
Okay, so, hi, I'm the one who emails everyone all the time. So you'll know which emails are most important because I will usually always put response requested in the subject line, and those are usually the emails I'm trying to ensure quorum and trying to coordinate everyone's travel. And these emails are really important to get back to me as soon as you can, so that way we can figure out meeting venues, meeting costs, all meeting related issues. And if we have to move meetings, unfortunately, which we hate doing, trust me, I hate moving meetings if I don't have to, but sometimes we have to. And canceling last minute, especially if you are the commissioner traveling that day, can be very costly for the department, because if you cancel that day, we don't always get reimbursed from the airline, or there might be other costs that might not get reimbursed, like the hotel. They might already charge your card before I get a chance to cancel. So communicating with me if there's any changes in your schedule is very important, so that way I can make the necessary arrangements. Speaking of travel, so rule of thumb, just hang on to everything. If you don't know if you need it, just hang on to it, send it to me. I'll throw it away if I don't need it. The way the state works is for travel reimbursements, they want the original form of the receipt. So if the original form is electronic, you can send it to me electronically via email. If you get a paper receipt, whether it's a boarding pass, taxi receipt, hotel receipt, I need that actual paper receipt and proof of hotel bags, boarding passes. So just mail that to me in the self-stamped envelope that I always provide. I try to provide all commissioners that envelope before every meeting. If you want a stack of them on the side, I'd be happy to mail you some, so that way you never have to pay for your own postage to mail us our documents. And as a friendly reminder, when you do use taxis, tips are not reimbursed. The state will deduct it. So if it shows a tip on your receipt, you will not get reimbursed. They'll deduct the amount and you'll only get reimbursed for the taxi fare. I think that's the only place you might tip. Everything else shouldn't really have tips. But yeah, rule of thumb, state won't reimburse your tips. Sorry.
Quick
Yes.
question. So if you do it on your phone, which I
Yep.
just did, I can send it to you.
Screenshot it.
Screenshot.
Yes, screenshot it, send me the JPEG, email it to me. Screenshot it before it disappears, because after you board the flight and you arrive at your destination, usually by then it's gone. So while you're waiting at the gate, bored, just screenshot it.
Thank you.
All right. Any other questions regarding travel reimbursements? I know it's very complicated sometimes. Okay. LUC equipment. So the LUC does provide iPads. I do apologize. They are a little out of date. They might not be updating to the most current iOS system. We will try to upgrade our equipment maybe in April if budget permits, but I won't know until April. But basically all commissioners must be able to access the LUC website. That is our key communication. We no longer print out paper copies of petitions for every meeting. We rely on the commission to see our website, access the information. If we have a hybrid meeting, you need to be able to access the Zoom hearing. And that's why we provide the iPad, so that way you have that equipment needed. You don't need an iPad if you have your own personal equipment, you're welcome to use, but we do provide what we have available. Any question?
Yeah, how come you haven't given this whole briefing? We could have done it in one day.
Are we gonna do that one day? Okay,
That was a joke.
I know. All right, moving on to the LUC website. So here's a screenshot of the LUC website. Everyone should be very familiar of it. This is our homepage. However, depending on what device you're using to access the website, it might look slightly different. So this is a screenshot of a web browser if you're on a monitor or computer. However, if you're on your iPad or an iPhone, Samsung phone, sometimes the layout alters depending on your screen size. But it will have all this information. It just might look slightly different. The one main thing I want to point out on the home page is every time an agenda goes out, when I email you that agenda distribution, it is updated on our website, and right on our homepage in a yellow, like post-it like box, it says next meeting. It'll have the date, agenda, draft minutes, docket page, and how to submit testimony. This is for all public. Everyone will be able to see this once the agenda is distributed. And we try to make it as user-friendly as possible. So when someone from the public comes to our website, they know our meeting is that day. Okay. Now, I know there's a lot of questions about Commissioner Checkpoint. Here is a basic screenshot of what it currently looks like. Here in Commissioner Checkpoint, you will have the same information on the meeting that was on the homepage. You will have the agenda, the minutes, the docket page, and the only thing different is you have a specific meeting recap on the bottom of that meeting, and that'll show any transcripts, YouTube, and minutes. However, that information is also available on the main website under agenda and minutes. So it's a little separate. Yours is a little all packaged together, but essentially most of the information is the same. The only time we post different information in the Commissioner Checkpoint is if it's an attorney-client privilege document, something that the AGs might have gave us as guidance for strictly you, not for public. Other than that, all our information is public information. All the docket information, everyone can access. It's not like hidden privy information. Our staff reports are posted on the docket page. Petitioners, public are welcome to read it. Yeah, I think that's a summary. Yes.
Commissioner Wu.
It said I needed a username and a password.
I thought I provided that to you.
Let me look
but-
at it, try.
I will send it again because yes, it does. Okay, I will verify that, or she will get it to you. Thank you. So moving on to docket filings. So all dockets related filings are stamped with the LUC stamp, which is, I guess, poorly positioned in the right-hand corner right now where the sign is blocking it. But typically every document received at the LUC will receive this electronic stamp. We ask everyone who files with the LUC to submit their electronic filing first and then submit their paper filing. So every document should have that exact stamp. If it does not have that stamp, it was not received by the commission. Any questions about docket filings?
Yeah, what's the typical amount of time you need by the time you receive a document to the time it kind of shows up?
So it depends. Examples like annual reports are rather quick. When I receive it, I check it for ADA compliance. If there is issues, I usually kick it back to the person who submitted it, ask them to address the changes. And then once they resubmit the filing, I double check it again, stamp it, log it into our log, and then post it to the website. So that turnaround could be anywhere from 24 hours with receiving it if the filing was perfect, or depending on how long it takes them to get it back to me, it might be another week.
How about written testimony in an evidentiary docket?
Written testimony, as soon as I get it, I fix the compliance because public testimony isn't the public's responsibility for ADA compliance. So as soon as I receive it, I fix it, I stamp it and post it. So that'll be, once I receive it, it'll be up in like half an hour.
Right, thank you. Surely.
Ariana, thanks. You do so much work. I don't know how you keep track of it. And keeping track of us is very difficult too. But is it now the official policy that whenever anything is posted on the website that you alert us and you send us an email to say, hey, something new has been posted? Is that correct?
So the way I do it is I do it at the end of the month. I keep track of everything that was filed, and then I send you guys a list of everything that was filed that month. Because in between everything else, I don't have time to email every single filing because I get filings what feels like almost daily, depending on what it is. But in that list, I don't include the public testimony because that's separate. That should be reviewed on the docket page. So that's why I kind of separate that notification to you guys, but I do it on a monthly basis and I have a log. So every time I receive it, I update my log.
Okay, so but if something comes in a week or days before the meeting, sometimes at the last minute, you'll let us know, right? You
Yes.
won't wait till the end of the month for that.
Right, no. So the things that I log is like annual reports, letters that we send out about delinquency. If it's a docket related filing that is for an upcoming meeting, I will email you guys as soon as I can.
Okay.
So even Waimanalo Gulch, I already emailed everybody about the exhibits are ready for review. It is a little beefy. Please review it ahead of time. You know,
Fortunately, some of us from the county have already reviewed that, whether.
well, not
It's an issue with
everyone.
And also, I think that there legislation or there was a clarification that if someone submits testimony that day of the hearing, we're supposed to, or we're allowed to look at it or something like that. Is that correct?
Yes, so if usually, well, it's a little tricky because I'm busy running a meeting or setting up a meeting, so I don't have the opportunity to check the general email box right before a meeting. But as soon as I see that testimony, I review it, stamp it, post it. But I do usually try to check it the night before in case there's any last minute filings, but I can't promise to always check it the morning of as I'm setting up, running tech issues, trying to figure out why the mic's not working or the internet's not connecting. But I do my best. Like,
Thank you.
any other questions about filings? Okay. Where am I? Okay, so I want to share for the new commissioners a little website shortcut. I'm not sure if all the commissions are aware of this website shortcut, but basically, if you know that docket number of what you're interested in learning more, or if we have an upcoming meeting, you just want to type it in real quick, it's the LUC website /docket number. So if you put luc.hawaii.gov/A92-683, you're there. It'll give you the main docket landing page. However, this doesn't work for every single docket because some are very old and they're not digitized yet, and I don't have web pages up for them yet. The dream is to have them all up on the website one day, but we are understaffed and I don't have time to scan. So yeah, that's a fun little shortcut for anyone. And even if you're doing your own research on an old docket, maybe that's not before us, and you just want to look something up, if you know the docket number, that's the quickest way to find it on our website. Any questions? Now, let's just go through a quick breakdown of how the website docket page is. And I want to thank Scott for templating this and designing it and making it so much more user-friendly than what it used to be. Because in the past, it used to be like a blog style, and you would just have to keep scrolling until you found OPSD's information or annual reports or anything. So this template has really made things user-friendly, easy to find. So here, I'm going to just use this example, A11794. This is the Department of Education docket page. So this is just what, there's two different templates for the website. This is what the main landing page would look like. And then when you go into individual petitions and motions, that template is slightly different, where the tabs are different. So for the main landing page, you're going to have the first post-decision actions, which is right here, if you could see that. So right here, you'll see all the breakdowns of the different years or motions that they had. So we have the 2011 petition for DB, that was original filing. 2019, they had another filing. 2020, they had another motion. And then 2023, we called them in a status report. So that you could see all the different years we've worked with them on this docket. The next tab is LUC notices and orders. Here you'll see all the orders issued for this docket, from the beginning to current. And we'll also have all the agenda and minutes. So if you need to review something that was done in 2013, you want to review the minutes, why the commission voted the way they did, it's right there for you. And then the next tab is correspondence. So any non-motion or docket related correspondence, just general correspondence on this docket would be placed here. Otherwise, if it's specific to that 2019 motion to amend, it would be in that folder instead, if that makes sense. And the last tab would usually be annual reports, and this will show all the annual reports we received for this docket from, I think this one says 2014 to present. So that's the first main docket landing page. Is there any questions on this layout or how to navigate it? Okay, so here's the second docket page template. This is what you guys are probably more used to seeing, because this is the motion specific, status report specific layout. So here we try to put a little bit of a background so the public knows where we are on this docket. And then on the first tab is all the petitioner filings. So here's everything received related to the 2023 status report. You're not going to see anything from the motion amends, the motion to reconsider, or the original petition. This is only information from the 2023 status report that was filed by the petitioner. The next tab is LUC filings. So as you can see, our staff report is posted for anyone in the public to read, any petitioners to read, OPSD to read. Any other LUC filings that we might post would be here as well. The next tab is OPSD filings. Sometimes they don't file anything before a meeting, so I'll just indicate no filings received at this time. If they did file something, then I would keep the link, and I always date it when we received it, which would show the date stamp in the right corner. Next tab is for county of the island filing. So this one's Maui. Otherwise, it might say county of Hawaii, city and county of Honolulu, depending on which island the docket resides on. And then this is our public comments tab. So here we usually, depending on the years, it might vary on how it was formatted, but the way we do it now is we put the date and how many public comments we received that day. And I date it by the day I receive it. So if they emailed me on a Saturday at 9 p.m. when I'm not checking emails, I'm not going to date it till Monday. Just to be clear, I don't date it the day they sent it. I date it the day I receive it. Just in case anyone in the public had concerns about that.
So a quick question.
Yeah.
So, and I'm really not trying to create more work for you,
Mhm.
but, Waimanalo Gulch,
Mhm.
I think their filing had 56 exhibits.
Something like that. Yep.
But I don't think that I mean, what was a little bit troubling for me
Mhm.
is I didn't know what was what. So is there a way that we can get um, the people filing the exhibits to name their exhibits?
So the file right above the exhibits is the exhibit list, and that has the title and the description
Each exhibit.
of each exhibit.
Okay,
Yeah, it was right above. I could pull it up later too to help point it out. Yep, yep, right there. Any other questions on that? Okay, so the last tab would be LUC notices and orders. This tab actually moves to the top if an order was issued after we kind of close out this docket or this motion or status report. If no order was issued, then I usually leave it on the bottom, but usually people are always looking for the decision order from the commission, so that's why we move it to the top if one was issued. But here I'll also post the agenda minutes and YouTube link, since now everything is also on YouTube. I think that's it. Any question?
is there any aspect of this information that we as commissioners are being asked to hold as confidential?
If it is, it's on Commissioner Checkpoint marked as attorney-client privilege.
Yeah.
Okay, so that's where, so,
Yeah,
so
that's what
if on the
differentiates the two.
checkpoint,
Mhm.
we see attorney-client privilege, confidential or some
Yeah.
proprietary.
Yeah.
But otherwise, we don't have to worry about it.
Yes, no, all our information is pretty much public record. I hope I didn't go too fast.
Hi, Rana, thanks. Question, going back on the calendar, I noticed like some are dark bold and some are gray. Does that have significance as far as where
So-
we're at?
The gray fonts usually indicate tentative.
Sure.
Black is pretty much confirmed in my eyes, but you know, sometimes the black things do move.
So that's what I thought. Just wanted to confirm that.
Yeah.
That's helpful. That's why.
Yeah,
See
yeah.
that
Black
dark
is
bold.
when I assume it's confirmed,
Yeah.
but you know, sometimes I get surprises.
Then when do we know, like, I know you were asking about August 9th, but right now I'm looking, it's August 7th and 8th. When you ask availability, when do we know that, okay, it's, forget about the 9th, it's still the 7th and 8th. So how do we figure that one out?
For that meeting in particular, I'm gonna let you know, I think Thursday or Friday, because staff has to discuss internally to verify and find a venue if we do move it to that date.
Okay.
Usually we have more time, but because that one's so quick is why I'll get back to you sooner. But I would usually send an email, or you could always just check the calendar, see what's been updated, because I update it, it feels like every week, but maybe it's every other week.
Okay, and then last one, on like, on the ones that just have tentative, they have
Mhm.
no meetings. I think I asked you this before, but just for everybody's education, when do I know that, because I block my calendar for the year because I got other board meetings going on. When do I know that that tentative one, I can just take it off my own personal calendar? 1 week, 2 week, or when?
So the agenda for that meeting would go out the Monday before. So I would be, and if you're an outer island commissioner, depending what island you'd be meeting on, I would have to make flight arrangements, usually 2 to 3 weeks before a meeting. So if I haven't booked you a flight, it more than likely it might be getting removed. But the Monday before would be the telltale because that's when the agenda goes out. If it doesn't go out on that Monday, then it's not happening.
So, thank you for booking the flights. So if we need to change the flights, the only two people that can change them are you and the passenger. Is that correct?
So for standby or like you need to change the entire flight?
No, before we even go.
Okay, so before even going, authorized callers is myself, Dan, Martina. I don't think Scott's on there. I'd have to check.
And the passenger.
And the passenger. That would be much appreciated. I'm just kidding.
Whatever it is.
1 week ahead, you want to change it.
Yep. Or I could do it. I mean,
Okay. Any other questions, commissioners? Thank you very much, Ariana.
yay.
think we're pretty much done unless anybody else has any more questions or wants to discuss anything else. Yeah, you're good?
Are there any members of the public that wish to testify on the training?
No, Mr. Chair.
Thank you. Is there any further business to discuss today, commissioners? Hearing none, do I have a motion for adjournment?
Move or adjourn. Oh,
Wait.
There's a lunch on the script.
Well, thank you very much. Reminder, I didn't see it. Was it in the script? No, we'll do it, but I still don't see it in my thing. I'd like to give this honorary gavel to Martina. As our August 7th and 8th meetings will be held at the airport, limited access to restaurants, and the commission intends to work through lunch, I'd like to request that the staff arrange for lunch to be provided to the commission to facilitate the meeting.
We will make those arrangements.
Thank
Mr.
you
Chair.
very much.
Does that cover the 9th in case it gets rearranged too?
Yeah,
Correct. This concludes our meeting. If I have a motion to adjourn.
oh, motion to adjourn.
Second. Moved by Commissioner Yamani and seconded by Commissioner Lee. All in favor, say aye. Meeting is adjourned. Thank you very much for the training.
thank you.